Oh yeah, we're live. Okay, good evening, everybody. What day is it? It's Thursday. It's not Wednesday. Midweek stream. When you guys see what this looks like, it's going to really look like the Brady Bunch of lawyers because we're going to come in four squares and it's going to be hilarious. First things first, how is everybody doing? I hope everybody is doing well. I trust everyone is doing well. Sorry, I got to swallow. First thing right off the bat, you will notice that we are in slow mode and it's 30 seconds and not 15 seconds. That is strictly because both of the channel moderators are going to be in the stream, so it's going to be tough to moderate, and we want to make sure to get to the to be able to follow the chat. Hello, Blake. Hello, everybody. What's up? This is going to be great. Now, in theory, the topic for the evening is SCOTUS, but obviously, we're going to have to talk about the Breonna Taylor situation. I know Nate is working on a video, but I don't know that he published it yet. So it's going to be amazing. Same disclaimers as always. Super chats. Thank you all in advance for the super chats. Joshua Cornelius, holy hell. Now I am certain that we are living in the end of times. Here we have the four horsemen of the apocalypse, all on the same podcast 2020. Cornelius, thank you very much. It is good to see you again. We're going to do our best to get to the super chats. If we don't, my apologies. If you're going to be angry if I don't get to it, don't do the super chat. It's to show support and it's to get the question up there, but I can't always get to them. And I don't like people feeling bad. So if you're going to feel left out or ignored if I don't get to it, don't do it. It puts pressure on me and makes me sad. Oh, did we just lose Barnes in the backdrop? Okay. Either way, tonight we have, I missed Bambuga's 19th super chat. Okay. Tonight we have Robert Barnes, Nate Broady, Uncivil Law, and we're going to have a roundtable. I mean, we're going to see how this works. In order to keep control, I have brought a stone that I got in Lac Saint-Jean over the summer. It's from an Indian river, and I got it because, it's supposed to relax you when you rub it with your finger. This is going to be the conch speaking stone, so whoever I point it to, in order to make sure we don't end up talking over each other, we'll have the podium? Whatever, the conch. We'll be able to talk. Let's do this. Let's bring them in. We're going to go in order of how I see them on the screen. So no particular order. Uncivil Law. Kurt, how you doing?
What's up? I'm having a great day. I'm happy to be here with everyone. Happy to be here with you, Viva. Happy to talk to Nate and talk to Barnes for the first time. This will be fun.
This is a first. We've had the three lawyers of the apocalypse.
I think we lost Viva.
I think we lost Viva. So remember a second ago how I was saying I was happy to be here and talk to Viva and Barnes.
It's our channel now. We run the show.
That's right. We don't need Viva.
The mod should take him over. Okay. Oh, he's back. He's moving again.
This is Canadian.
No.
Yeah, he's frozen up again.
Okay. So how's your day going, Nate?
It's going good. Hey, Robert, what's going on?
How you doing, Robert?
Here.
Yeah, now I think Viva is back.
Yeah, he's back now.
Or maybe not. Yeah, he keeps freezing.
He's freezing up. Are you back, Viva?
Yes. No.
I think he's not back. There it is. All right. He's frozen.
It's you keep pausing in, pause it now.
Well,
in lieu of Viva here to moderate, we may need to appoint a new conch master.
I'm never using this computer again. Is what's happening. Okay, you guys talk. I'm gonna get my power.
Hey, listen, I'm gonna tell you guys something that happened to me today, right? So, as you guys know, I'm doing the lookup on the Breonna Taylor case, right? You know how I like to do the police shooting cases. So, I'm going through all the information. So, I'm going over it with my wife. Now, my wife is you think I'm lefty? She's like, way like Breonna Taylor was murdered and all this. So, I'm like, okay. So, we went through all of the evidence that I found, the warrant, because you know me, I like to go through the warrant, I like to go with what the background was, so I go through all of that. And after that, she said, "Oh my God, the media has lied to me." I'm like, now you know how I feel. yes, they've been lying to you. Now you know how I feel. So it's been insane, and I'm actually honestly scared to now make this video because I believe there's going to be like a little backlash against me. Because I don't think anybody really knows the facts of the case. Like the facts that have been put out there have been just straight up lies. I don't like even with remember the Georgia case with the cop, and they were saying that a taser is not a deadly weapon. It's like, why do they just make up lies like that? You know, the Supreme Court, just like last year, said it was a deadly weapon, and now they're going to come and say it's not when a cop. It's like, it's insane. I'm sorry, I'm getting on my high horse and pearl clutching a little bit here. So
but Nate, I think we may as well just start on this subject and then move into SCOTUS because
Sorry, so I was just gonna ask Nate if he saw Cheryl Dorsey, this retired sergeant from the Los Angeles Police Department, was on MSNBC and called the Black Kentucky Republican Attorney General, who said, not so much for the charges, called him skin folk, not kinfolk, because he's not really black, because he reached the wrong conclusion despite being a black attorney general.
You know what? When it's funny.
Skin folk. Good.
No, it's you guys may not understand this, but when I saw him, I didn't even think about his political affiliation. I just thought I was proud to see someone who was up there as a black man in that position, coming to a decision that was not political, that was just based on the facts. Most people don't know Breonna Taylor's house was considered just to go into it, drugs were being delivered to Breonna Taylor's house. Most people don't realize that. Most people don't realize that she was questioned for a murder that was committed in a car that she rented. Most people don't realize that. Most people don't know. Most people do not know that the way it was working was her ex-boyfriend was getting drugs delivered to her house, and they have all this on camera. They have all this on tape. They followed. Well, let me bring it back, because I know a lot of people out there don't know the terms I'm going to be using. In the hood, we have you might have heard of the term crack house. Now, crack house is actually a term used with what we call a trap house. A trap house is a place where people sell drugs out of a trap house. So people come, and it's easy for cops to find trap houses is because there's a lot of foot traffic. If you're in a residential neighborhood and you got a lot of foot houses going to a house, you know that there's something fishy going on. So we call those trap houses, and they're easy to spot. And in the Breonna Taylor case, there were a lot of people calling about a trap house that was in the neighborhood. So police went to that trap house and raided that trap house. After they raided the trap house, then you try to find the distribution chain. Now the trap house usually gets its drugs from what we call a stash house. A stash house is the place where the drugs and money come into, and then they're distributed to the trap houses. So the police, after finding the trap house, they then surveilled the trap house and then found out where the drugs were coming from. And the stash house for 3 of these trap houses were Breonna Taylor's apartment. That's where the drugs were. And they have surveillance of the cars going from the trap houses to Breonna Taylor's house, picking up drugs, then taking them back directly to the various drug locations, to the various trap houses. Breonna Taylor was caught on a phone call when her boyfriend, the ex-boyfriend, got arrested. She was caught on the phone call. Quote, the other guy who was arrested, he's back in the trap house. So she knew what was going on. But see, the thing is that most people who heard the story know nothing about this. They hear that she's an EMT. They don't hear that she's on the phone talking about, going to trap houses and all this stuff. And don't get me wrong, I do understand. Like one of the big issues too is about the no-knock warrant. People are saying, well, it was, it's a no-knock warrant, and now they've outlawed no-knock warrants. The cops knocked. The cops knocked on the door, and that was the problem. They knocked. They should not have knocked, and the fact that they knocked, that was the problem. It wasn't the fact that they did get a no-knock warrant, but they didn't use the no-knock warrant. They stupidly knocked. So it's all, there's a lot of misinformation out there that I try. I'm gonna, you know how I do. I pull it apart in the video. So when the video comes out, you'll be well to see it.
2 things. So someone had said, Nate, do not be afraid to speak truth to lies. So many don't know the truth. And incidentally, Nate, if you were not reading the chats before went live, apparently people think you have a leftist bias, which I don't know. They may read after this next video. When does the video drop? And then I want to ask Barnes a question.
I'm sorry. The next video is going to be probably dropping tomorrow, because I'm still doing more and more research. But it should be. I should be finishing up tonight and editing out. So it'll be out tomorrow. The Breonna Taylor video. So
okay. And now, Robert, we've talked about this many times. You have a philosophy which seems to be panning out to be true more often than not, that once these big cases go public, or the ones that get picked up by the media, tend to be the worst civil rights cases. I'm not sure how much of the facts that Nate just mentioned you're familiar with, but I mean, what's your take on Breonna Taylor?
I mean, I think it's a mixed story. I think when we did our, I think we covered this maybe a month ago. I went back and watched part of it actually, and I think we predicted about 99% of what happened, because what we went through that it wasn't the clean case that the media was presenting it as, but that there probably were problems in the way Louisville's PD handles warrants. Because some of what Nate is describing was not in the warrant. Some was, some wasn't. But there are other problems, I think, with the warrant. The best evidence that there are probably problems with the warrant, the city of Louisville settled that case quickly. They paid your family $12 million. I can tell you that cities don't write that kind of check unless there's some discovery they don't want out in the open. So my guess, but for folks out there, there's two separate parts of the case that the media isn't fairly describing. The Attorney General for Kentucky tried to get into it yesterday. Everything about the warrant is not what he was investigating. Everything about the warrant is what the FBI is investigating. He was only looking at the 3 officers who did the shooting, and the 3 officers who did the shooting had nothing to do with the warrant. So, I mean, Nate can attest to, as being a former police officer, these are cops called in to just execute a warrant. All they know is what they're told. And they clearly were given the impression that this was maybe an impression that wasn't necessarily as justified by scoping out the property as much as I think they should have. But and there was one cop, the cop we mentioned on our broadcast, that I said there was one cop with a bad history. He's the one who was charged with reckless endangerment because he just went bum, 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 bum. He was outside the building and he had like 10 shots, and a bunch of them went into the neighboring apartment. And there was a pregnant mother and a little kid in that apartment. I mean, it was a miracle nobody else died. The other 2 cops had always much cleaner case because they come in the door, they get shot, and one gets shot, and then they fire back at the direction that they got shot at. And I think they only shot 6, I think somewhere between 7 to 10 times. One problem I had with the Kentucky Attorney General yesterday was a little vague on all the shots. Like, for example, I'm a little curious how they came to the conclusion of what the bullet was that was the deadly bullet. It's like, my understanding is there was a 15-minute delay between the entry to the property and her time of death, according to the coroner. That 6 bullets went into her. How exactly they figure out which one was the deadly one?
There was a split from the labs too, because the Kentucky Attorney General said the in-house lab couldn't come to a conclusion, and then they used some sort of outhouse lab. Was it FBI? But they were able to come to a conclusion. Yeah,
the FBI did come to a conclusion, and the FBI said that what the bullet was. I can see why my friends on the left or on the skeptical side of this case are skeptical of how that transpired. It's kind of like the George Floyd case, why the Uncivil Law has talked about it. Well, the prosecutors DQ'd up there. The skepticism by the judge, I suspect, up there is he doesn't like that they decided to meet without a witness because he's concerned that there's going to be an allegation that they coerced the coroner's testimony. The coroner changed his mind, and the coroner won't admit it, and so on and so forth. The defense lawyer is clearly already trying to hint at that. We don't have a full record because apparently that was said verbally, and then the judge issued his opinion, and the state asked for reconsideration. It was a highly unusual disqualification, I can tell you that. But that tells me that there's probably more there than what the judge maybe put in the ruling. But so I think from the Breonna Taylor side of the equation, it would be concern as to whether or not that they still dispute whether there was an announce. There was no dispute. My understanding back when we talked, Viva, was that my understanding at that time was that there was no dispute that the knock took place. Now
they did in fact knock.
Yeah, because that's what the guy who shot back said. He said, I heard a bunch of noise. I heard a bunch of pounding at the door, and I didn't know who it was. The dispute is whether there was an announce. They apparently now have one witness who said he heard them announce police, though there again, the Kentucky Attorney General was a little vague about what exactly that witness said. So again, I think Nate is fundamentally right that most of the facts were badly misled. A lot of the media coverage focused on the fact that the warrant was a no-knock warrant without disclosing the fact that it was mostly uncontroverted, as far as I knew, that in fact the knock occurred. The disputed part was whether an announcement occurred. Based on the 911 call made by the person who shot back, he clearly didn't know they were police. Put it this way, it's pretty weird to call 911 if you think that's the police coming in your door. And then the worst problem for the cops at the time was they didn't find anything. If they had found a money stash, if they had found a drug stash, the case would have presented easier. The other problem was it appears that some cops lied in this post report. Like they filed a report that said there was no forced entry. Apparently they used the ram to enter the door. That's usually the definition of a forced entry. So I think what happened is it went AWOL. largely, and that the 3 cops who were involved in the shooting were being treated as fall guys. Now, one of them has been dumb enough to do drunk emails at 2 in the morning, writing to the entire PD about how the FBI is a bunch of pussies and so on and so forth, stuff that's very ill-advised. When he writes it at 2:15 in the morning and he himself says he's rambling in the email, he should have put in some algorithm to his email so that it would stop it from. My brother had to do this years ago. He had to put an algorithm in to stop him from responding to people when he got ticked off, because he'd be like, oh man, I shouldn't have said that. So I think Nate's fundamentally correct. Most of the facts were not known because the media lied about it. And it does go back, whenever BLM celebrates a case, they lie about it. We talked about Viva, what Crump put in the lawsuit. He didn't even talk about the fact that he shot back, and he probably shot back first. And he didn't, the guy who they originally tried to they originally prosecuted and then they dropped the charges, who shot back first. Because you can't have a situation, folks, where both sides have self-defense, because both sides don't, from their perspective, they think they're defending themselves. The evidence was that was the case. But I do have doubts about whether the cops definitely announced or not. Unfortunately, it turns out in Louisville PD, the only people who wear body cameras are the patrol cops, not the people executing a search warrant like that. That's why I say, I think if you dig in, I think what's happening here is these 3 cops were being used as fall guys for the screw ups in the warrant process, issues with body cameras, issues with what happened afterwards that go to the higher ups. And the higher ups are probably the ones that are under major criminal investigation by the FBI. And they were looking at any excuse to say, no, these are just a couple of idiot cops who did the wrong thing. It's not because we have systematic issues with it. Like, it's clear, like, for example, they apparently came out afterwards. They didn't know whether there were kids there. They didn't know whether there were animals there.
They had no ambulance route for just in case.
Yeah, this is, as Nate can attest, that's a sign of a poorly prepared warrant. So they brought in these 3 guys to just take all the heat. And I think 2 of them got unfair heat. The third guy that shot too much, especially had a history of it. I support the reckless endangerment prosecution of it.
Yeah, you know what? But it's interesting because whenever you like, I've done many of these warrants, right? I've done many of the warrants based on informants, and I wrote some of these warrants when I was at both the Brooklyn DA and the Bronx DA. And one thing, especially with a no-knock warrant, one of the most surprising pieces of it is, why would you only use a 3-man team to issue a no-knock warrant, especially if you think there's going to be, because the warrants that they had executed warrants previously to some of these locations, and you find guns, you find knives, you got people who are running from the police. So to issue a no-knock warrant, you know that there's going to be some issue of violence there. So 2 things, why would I just have a 3-man team, 2 in the door and 1 by the window? And then also 2, why wouldn't I go in hard? Why knock it all, right? Because if you are going to knock, for those of you who don't know how it usually works, if you're going to execute a warrant, it's not like TV where you're just banging through the door. No. If I'm executing a warrant, that's a knock warrant. It's a knock and announce. You knock on the door, the person opens the door, we got a warrant, and we rush in. That's generally the way it works. It's not boom, 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 police. Sometimes if the judge doesn't want to give you a no-knock warrant, you'll do a hard entry like that. But 99% of the time, it's a simple knock on the door. The person comes and opens the door, and you're rushing. That's generally the way it would work. But in this case, to have a no-knock and then knock, it just didn't make any sense. And then usually you have a surveillance team there for a couple of hours to surveil the area. Are there kids? Who's going into the house? So you kind of have a good idea of what's going on before you send people in. But now it seems like these 3 cops just showed up to a door and was like, we're going inside there. That's TV stuff again. In TV, you hear that, let's go to the house and knock down the door. No, you surveil it, 5-6 hours. Who's in? You got kids in there. Who have you seen coming in and coming out? That's generally the way it works. So yeah, so I think there's a lot of problems with the process. I think they got lax. But if you're talking about this, just the use of force criteria, when the 2 cops who got shot at, they returned fire knowing where their target was. The 3rd cop, he heard the shots, heard over the radio, police got shot, and he just fired blindly into a location. That cop, that's reckless endangerment. No, there's no jurisdiction on the planet that's going to allow you just to shoot blindly into a space, even if you heard shots fired, because you don't know who's fired. They could be cops, for instance, shooting those shots. So yes, so that was, and that's why he was fired. But the other side, where that the big issue is, why would you send a 3-man team to a hot warrant to a stash house where you think drugs, guns, and money are going to be, and a registered gun owner is living there too. Yeah, it's just there's a huge mess in the procedure, and I agree with Robert. There's more here on the police side, and that's probably the reason why they gave $12 million.
So Nate,
and plus Nate, you can probably speak to this. This is also an apartment building, so this
Yes.
isn't like a house. So the capacity for things to go sideways are off the charts.
Yes,
so that's why there's usually a lot of protective procedures. And the other component that Nate highlights, you almost never, when you have a no-knock authority, and maybe they were told by the judge, I really want it to be a knock and announce, but then that's on the judge to change the warrant. But it's very rare you hear 3 knocks and then take the ram and break down the door.
Why bring the ram?
Exactly, it doesn't make sense.
so
It doesn't make sense.
we'll bring up this super chat, which has been here for a while. The bad optics of the officers being in plain clothes. Now a question for all of you. Should officers serving warrants have to have plain visual identifiers that officers are police, not just vocal? Because this is the one thing everybody says, oh, great. Now criminals know how to bust into somebody's house. Just say you're the cops and then enter, and then they can't defend themselves. So the no-knock warrants versus the knock warrants, we discussed the risks of both, especially the risks of knocking when you have a no-knock. You give them a chance to arm up. But plainclothes officers, how does that work in the context of this type of raid, for lack of a better word?
Well, let me. Well, first, there's a warrant. Well, if you're executing a warrant, the element of surprise, no matter if you knock or you don't knock, right? The knock and announce is a common law thing where you're going to SU, you got to knock and announce. Now, to be honest with you, constitutionally, you don't have to knock and announce. If you bust into the house and get whatever it's not, the evidence that you find is not going to be excluded. There may be some civil penalties, like in this case, but you don't. The requirement is not the knocking doesn't permit the evidence from not being used in court. So cops do it as a courtesy and do it to avoid civil liability. But you can just bust through the door. Now, the reason why cops generally, like in this particular case, when they had the first 3 raids, right? Because they had 3 raids, and most people don't realize this was a 4th raid encompassing from the information from the first 3 raids of the trap houses. So this was okay. Now cops like to move up the chain. We're going to the distribution center. So what happens is when they raided the first 3 houses, they found surveillance equipment, and what these people were doing was they would have cameras all around the property. And if you see cops coming toward the property in police cars, what you would do is you start destroying all the drugs, destroying all the evidence. And this is why, if you look at some of the charges from the people in Breonna Taylor's case, tampering with evidence, destroying evidence. That's what some of the things that they were charged with. So in this case, you want plainclothes officers to go because you want to keep that element of surprise when they get to the house. And that's what you're looking for here. But again, even though the way you would usually do it is that you would have your patrol cars, the people with the uniforms, maybe a block or 2 blocks away, where they will not get caught on surveillance. You got your plainclothes team go in. They then set up, right? Because now you got your surveillance team who's already been there, who's already telling you, all right, there's 2 people in there, blah, 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 blah. You set up, you go in hard, you don't knock, because the reason why these cops even got shot is because they knocked. If they went in hot and ran into then it doesn't give that guy time to get his gun. That's the reason why you get the no-knock warrant. You get the no-knock warrant to prepare the person in there so he can't get the gun. You go in hot, you grab it. But again, a 2-man team, very suspicious. Usually you want more because, and you get a layout of the house. So that's the reason why it's better to go plainclothes, especially if you're going no knock, because you want to keep that element of surprise. If you got people going in uniform, evidence is going to be lost. I know that was a little long-winded, but that's generally the way it works.
And we have a disagreement, or at least a question of fact. They hit multiple houses that night. At the briefing, Breonna's was downgraded to low threat. Warrant was changed to a knock and announce. Nate,
no, I've seen the warrant. I got the warrant. It's not. The warrant was
the warrant was never changed. Yeah,
the warrant wasn't changed.
Apparently, they internally decided to knock and announce, but that means they've got a completely conflicting messages going in. That's just a disaster waiting to happen. One, if it's low threat, then you don't even need to go in at 12:30. I mean, that's the other problem. When you're doing a hybrid no knock and not, you normally do not do knock and announce after midnight.
No,
because people are going to get confused. They don't know what's going on. I represented some people in the alternative product distribution business, and they're highly sensitive to people trying to rob them at that time frame. And so they came out guns blazing, but they knew how to handle it and chilled everybody out. But the probability of shooting back is always sky high when you do it the way they did it. And that, again, that's 90% of that is on. I put only a little bit on the people executing the warrant just because one of them was a sergeant, so he should have asked some of these questions, I think. And as he should have been, hold on a second, there's a problem here, there's a problem here, there's a problem here. But it appears they were accustomed to following whatever the direction was, rather than, like, if Nate was there, it would have been, hold on, we're doing this, or this. Why aren't we doing this, or this? So that's why I say there's a systemic problem, I think, in Louisville PD. There was some problem where the questions that cops that do this every day would ask somehow didn't get asked. And it's to avoid problems exactly like this from occurring. But it was never the case that they went in to murder Breonna Taylor.
No.
That was always a lie. The NBA players were lying, and Major League Baseball was lying. The media was lying. And I do believe they often do it deliberately because they like divisive cases, because uniting cases lead to reform, but they also don't lead to political revolution. And if you believe in political revolution as your premise, as BLM does, then you need divisive cases. And you only get divisive cases if the facts aren't really good when you dig into them, because otherwise you want to have two people on both sides. You know, if everybody looks at the case and says, oh, that's a bad case, you're going to have 90% of the people agree with you. There aren't 90% of the people, well, maybe some of the people backing Amy Coney Barrett, a little authoritarian wannabes, little, South Park Cartman cop wannabes. Maybe some of them will, but aside from them, the rest of us are still sane and don't support police abuse if the facts actually prove.
Wait, now hold on. The speaking conch is going to Kurt.
Yeah. Well, putting aside the Amy Coney Barrett comment for the moment, it seems to me, first of all, it's my understanding that they were doing multiple simultaneous warrant executions. So there's more than one going on at the same time. So I could certainly understand why in the dynamics of trying to figure that out and trying to figure out where your resources need to be at any given moment, why you would change on the fly, even though you had the latitude to go for the no knock, that you would say, well, our resources need to be here otherwise, because presumably they had surveilled the property in the past, so they had a general idea of who might be there at any time. And so that's one of the reasons they said, well, it's low risk right now. And
apparently they didn't, Kurt. Apparently, according to
at any point,
at least from what I've heard so far, is that apparently the cops said that the ones that went in, they said, do you know who's in there? They said, no. They said, if any kids are in there? We don't think so, but no.
That's a problem. That's a problem.
Yeah. I mean,
you don't go. Like there's no way in New York where you go into a place not knowing who's in there. It just doesn't happen. It's just because you got somebody sitting in the house. Especially
you don't know who's next, who's nearby, who's on top, who's below. If you really think this is a drug issue, you want to know who the neighbors are. You want to know it's not uncommon to have multiple of those units controlled by people. So you might be coming out and being hit from the side or from the next place. You don't know. You don't know where the exit points are. This was a warrant. This was a disaster of a warrant. And I don't blame the cops who executed it. Only a little bit. It'd be better if they'd asked questions like the Floyd cops. Maybe 8.5 minutes is too long. Maybe say something. Maybe at some point you do have an affirmative obligation, even if that guy is superior in command. But by no means are they mostly responsible. And no. They didn't set in to kill her, and there isn't a valid murder charge unless one of the reckless endangerment.
It just seems to me, I want to assume that they're rational actors and professionals, and that they have protocols that they normally follow. So, I obviously understand that police can do bad things and mess up, and there can be systemic problems. But all that being said, I don't want to necessarily assume that without evidence. I want to go the other way and give at least the benefit of doubt and say, look, these guys are professionals. This is probably not their first drug raid. They probably had reasons for doing the things they did in the way they did it, and evaluated things on good faith. Now, that may prove not to be true in the end. And Robert's point that maybe the reason they sell it for $12 million is specifically because there's a lot of dirty laundry behind the day. Maybe that's the reason. But all that being said, I'm a little uncomfortable just assuming that. So I want to assume good faith and try to figure out, why might they have made the decisions they did? Does it make sense? And so that's kind of where I'm trying to start from.
If it just going on what you just said doesn't make sense, I'll tell you this: you don't do knock warrants at midnight. Why? Because if somebody's knocking on your door at midnight, there's already a problem, right? If somebody comes and knocks on your door right now at midnight, Viva, do you think they're coming to deliver something versus midday?
I'm calling the cops if that happens.
If they are the cops, that's why if you're going in no knock, you're going no knock when people are sleeping. Why? Because it's going to be harder for them. It's dark inside the house. They're looking for stuff. Oh my God, where's my gun? That's why you go in at night. But
well,
I don't
necessarily like the implications of that, because there are a lot of people, including me, who question the existence of no-knock warrants as an idea. And that would mean that if we got rid of no-knock warrants, it would mean that we couldn't serve warrants, after dusk and before dawn, which maybe that's the way we're going. But it seems problematic.
I'm saying you can serve no-knock, like you could serve knock warrants whenever, but it's just as a tactical matter. If I want to serve a warrant on you, I want to serve it, number one, when you're there, when I think the contraband is there. And I'd rather just come knock at your door at 5 o'clock. Why? Because you're going to open up the door, unbeknownst to you. Oh my God, the police are here. And then we bust in. That is the way 99% of the warrants are done. If I'm coming in no knock, it's because I think you got guns and I think my safety's in jeopardy. So I want to rush in to make sure it's dark. So you're fumbling around in the dark and you have no opportunity to grab your weapons. I know Barnes. You know the game, right? This is the way it's played.
Almost all your knock and announce warrants are usually 6 a.m., 7 a.m.
Yeah.
They go in early in the morning, right about when you're waking up, knock to get everything done. They're there all day. They want to interrogate while you're awake. They don't like going in between midnight and 5 a.m. because people might be drunk, people might be high. You might, they may be you people are going to be at maximum state of confusion. You're not going to have a lot of light. So it's these kind of problems, these kind of shootings. Disproportionate risk goes up when you do a knock and announce between midnight and 5 a.m. So they generally avoid that for a whole bunch of reasons. Definitely in an apartment building, because you don't know who's coming at you from different sides, what else is going to happen. You want it to be bright. You want it to be bright and early in the morning, and that you want to be their wake up call. You want to be their alarm clock, but you want it to be around the time of an alarm clock. And if you're going to do a no knock, you're going to do it the way they did it to poor Paul Manafort, where he and his wife were naked in bed, woke up to guys with guns. So that's normally the procedure to avoid all of these risks that we're identifying. And it's not legally required; it's just tactically wise.
Before, I have one question for Nate, who I know knows the facts better, but I want to read Little Rock's chat. He says, I told you guys I had a client meeting at 6 p.m. and to wait until 6:30. Now you have to catch me up. Sarcasm. Glad all four of you are here explaining all of this. I wished it was on CNN, MSNBC, Fox. Better chance of us being on Fox than CNN, I think. But Nate, this is the question. I mean, I'm waiting for your video. I'm waiting for the facts. I know people have been tweeting out today, about this murder investigation into a car that Breonna had rented years ago. I know my initial reaction is the same that I had with George Floyd. I don't care about past criminal history on the day of the event unless it's somehow factored in to the events. So did these cops know that there was this investigation? Was that a relevant factor in anything of the warrant? I mean, was that a relevant factor the day of the incident? Nate, you're on mute.
I would say no. For the reason why is because I don't think it's like, I'm not even going to mention it in my video because I don't think it's relevant. But what I do think is relevant is the relationship to the other raids that were happening. Because don't forget, there were 3 other raids that had happened before at these stash houses. And the reason why they were raiding this place was because they had a definite connection between her place and these 3 distribution centers. Like they literally had cars going from her place to these 3 stash houses, and the packages being delivered to her house. I think they even questioned the postal inspector to say, that they're getting all these packages for her ex-boyfriend, and the ex-boyfriend would go pick up the packages, and the police would surveil him to the stash houses. So that's what seemed to be relevant. So a lot of the news media was saying, number one, this was because it was a no-knock warrant, right? The police didn't knock. Well, they did. They were saying that the police didn't announce. Now, the DA said that they had a witness, a next-door neighbor, who heard them bang, 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 and heard police. That, and they believe that witness is credible because that witness is, is disinterested from the case. It's just like, it's a next-door neighbor. Why would and that was a first impression. Hey, what did you hear? We heard the police bang, 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 police. That changes the narrative. And then the second piece of it is that the narrative is that this is some innocent bystander who just happens to be there and been gunned down, and that's and the fear is that it's making, I think, people think that I can be laying in my bed and the police will come running in my house shooting up the wrong house. That's not what happened here, right? That's not what happened here. Breonna Taylor's name was on the warrant, right? The person who literally was arrested, who she bailed out for distribution of narcotics, his home address was Breonna Taylor's home address. And I think people just don't realize how, now, don't get me wrong, she could have been trying to get out of the game. which is possible. But at this moment, her address is being used by felons who are distributing narcotics. They are traveling to her house, to the stash houses every day. They are in a car registered to her name, going back and forth. A car that she had rented had there was a murder that occurred in it. So it wasn't like this was some fawn in the woods. There's a lot of facts. The reasons why the police were there, I think, were right, but I think the warrant could have been done better, and I think the execution of the warrant. And that's what we always said when I was in the academy. I used to always say bad tactics lead to bad use of force, and that's what happened here. These were poor tactics, because if you have a no-knock warrant, you're going no-knock. But since you knocked, that allowed this guy to get his gun, and now you have this huge problem. Bad tactics lead to bad use of force.
That's also part of the reason that I question the idea that there might have been a problem in the warrant, because even if there was some kind of problem in the warrant, if the police knew all that things and they spoke to the postal inspectors and they knew packages were being delivered there and they knew all the stash houses were going there, even if they somehow made a mistake in their affidavits or somehow made a mistake in the application, they could have gotten a warrant. It sounds like they had more than enough for probable cause. So even if there was some sort of problem in the warrant, or even if the cops somehow lied in their affidavits, it sounds like they could have gotten a warrant regardless. So it doesn't seem like it would have made a material difference one way or another. So that's part of my concern too.
There's two different components of it. The primary issues is the procedures around the execution of the warrant. So it's all the tactical decisions that were made that are contrary to at least custom and practice in all cases that I know of like this. And that is the highlighted concern. And that's what I think goes up the food chain, because normally there should have been more supervisory involvement, especially when, they take no-knock warrants very seriously because they're the highest risk to police officers, highest risk to other people. Most departments that I know, they are very careful about that. It gets multiple levels of supervisory review. You have all kinds of surveillance of the property, often for days prior to going in, and definitely the day of. Apparently that didn't even happen here. So it's more that aspect. Now, I think some of the issues, that's what I mean by problems with the warrant. Now, the smaller secondary component is that apparently they had a lot of information they did not include in the warrant. And the reason why that's significant, it's just that people were a little taken back that a warrant that thin could authorize a no-knock warrant after midnight.
Yeah, that's true.
And the Breonna Taylor supporters or skeptics of the police here would say they think that a lot of this was discovered after the fact by Louisville Police Department trying to put together a better argument than they actually had available to them at the time of the warrant. In other words, they went back and listened to all the audio with the defendant, everything that was done, started leaking that in multiple places. I don't know whether that's true or not true. I know the audio pre-existed it. I don't know whether they listened to it or not. I do know when I first read the warrant, I thought it was thin. For a no-knock warrant, I thought it should have been much thicker. But I put most of that blame on the judge. A magistrate should look at this and say, okay, I know they see more warrants than anybody, more warrants than a lot of the cops drafting warrants, and they should have said, hey, come back with this and this and this and this before we do this and that. And I think the Louisville police power structure is trying to protect the judge and protect the hierarchy. And the mayor's trying to make political points, and that's why a lot of this information was withheld from the public in part.
Well, Robert, I just want to stop one, because, all right, sometimes when you get these warrants, you're right. The warrant was hell of a thin. It was thin for no knock. I would agree with you 100%. You should not have gotten a no knock for this, but I think if this judge signed, because usually you go back to the judge who signed those other 3 warrants, right? Hey, this is a stash house, and if that judge sometimes, and this does happen. It's happened to me, where the judge looks at it and doesn't really read this particular, because the judge's supposed to read each warrant individually. That judge doesn't read this warrant. He kind of just assumes, well, it's a her in this case, assumes those other warrants are just like this warrant, and then authorizes a no-knock. But you're right. If you just look at this warrant independent of those other warrants, this was definitely not a no-knock warrant. And I think that's more of what would happen. Instead of, I think this judge just said, if this is with these other cases, go ahead, no-knock. And boom, that's where you get your mistake.
I think she also turned down the warrant on the baby mama based on conversations that they later released. The main drug defendant target was surprised they didn't raid her. There's been discussions that there was originally a 5th property they were going to hit that they didn't hit. I suspect that that's what the judge in her mind was doing. She was like, okay, this is just the girlfriend. My guess is she was a money mule in the business. In other words, she was a place he could stash some cash. He was a place she could be up front, basically, for certain. But I particularly given the kind of comments he's making later on, how these guys keep talking on jail phones after the fact, I don't understand. Like I said, everybody, never in writing and always in cash. Also, don't talk on a recorded phone call. But he hints at that. He hints at that consistently. Now, he was ticked off because people were blaming him for Breonna's death, but he kept hinting, well, she's doing this for more than me. And that would be my guess. But it's still an unfortunate incident that I think could have been avoided with better policing. That doesn't mean the two cops who did the shooting didn't have self-defense as a defense.
Kurt, I saw you wanted to say something a few seconds ago. Okay, so here's my question. When you bring it up, well, first of all, someone had the comment, do you think the police were there to shake them down and it went bad, hence no money?
Not these three cops, because they had nothing to do with the case.
They didn't even know what they were going in for most of
This is the question. I mean, Nate, Kurt, Robert, I don't know the answer. With the warrant being so thin, is it thin because the cops are lazy, because they're doing it rushed, because they've gotten into bad habits in terms of not having to justify warrants enough, or because they know the judges don't really read the warrants anyhow and just sort of give them a rubber stamp? Like, I don't know what the practice is, but
it has to be poor supervisors. Your average cop will often come up with just the basic facts, doesn't want to get into doesn't want to sit, they hate paperwork already. They don't want to spend 10 hours, 20 hours, 30 hours just looking at the fourth ranked priority property on the warrant. This was always the bottom of their priorities. The stash house was much more important. Hitting the drug deal was much more important, et cetera. This was just, maybe we'll get lucky with this last property. And so that's on the supervisors. So it's almost, in every case I've had, a civil rights case, the supervisors are the good ones. They're meaningfully involved. They're constantly reviewing. If we compare, say, that's why there's red flags with the FISA cases involving General Flynn. A lot of reviews that normally happen somehow wasn't happening, which was a warning sign. Normally they're very involved, because your line cop, particularly like these cops, I don't know how many warrants they may have done, the guys that are on the drug force. It couldn't have been too many warrants because they weren't even going to be the guys to enter. So that tells me that, at least as far as I know, unless they were entering at one of the other properties. So I have some doubts that these guys, my view is it's all on the supervisors, almost guaranteed, when they dig into the evidence. It would also explain why the city of Louisville Police Department was anxious to throw these guys under the bus.
I wanted to return to an earlier comment where it was pointed out that when you're doing no-knock warrants, they tend to be reviewed internally within the police force at many different levels of review. And so maybe what happened here is that they were planning these multiple simultaneous raids. And one of them, they wanted to do a no-knock raid at night. So they were initially planning their logistics around that, because they're going to do these multiple simultaneous raids. And then as part of that internal review process, they decide, well, actually, no, we don't want to do it anyway. But since we've already planned the logistics for this particular time, we'll go ahead and execute the knock warrant at this time, along with the simultaneous other raids. So again, it seems like there's reasons that it could be done this way. We want to hit multiple places all at the same time. We have to coordinate all the officers to be there at the same time, do all these raids at the same time. We have this internal review process, and we decide, you know what, after all, let's not do this one no knock, but we want to execute at the same time because we're trying to get everyone as part of the common, criminal enterprise. And so that's how it seems like it could have come together to me.
Yeah, and that would be fine, except you either do a no knock and ram, or you knock and announce. You don't do a knock and ram. That's the problem. So as Nate says, that's the police version of events. That's not how actual police, the TV version of events. That's not how the police do things, because they know it causes these problems. If there's no point the ram is just going to terrify everybody inside, and they're going to panic, and they're going to be ready to shoot you when you walk in.
So you think that when you have a knock and announce warrant, if no one opens the door, that you should just go away?
No, you
instead
wait.
Of breaching,
you give a reasonable interval, especially if you're doing it. Let's say your theory is the reason for the timing is at 12:30 is because they're doing the others that are no knock at 12:30. Okay, but if you're going to do no knock at 12:30, and I've seen a lot of these done, they do not use the ram very quickly at all. They'll knock, and then they'll knock, and they'll knock, and they can attest to this. Usually it'll be a minute. It'll be some reasonable interval.
I think that was what was testified to. Maybe it was the AG, but I seem to remember someone was saying it was a minute from the time they started knocking to the time they used the RAM. That seemed to be the time frame that someone was saying.
Well, I would say generally, if you sometimes you do use a RAM for a knock and announce warrant, but what happens is you're banging on the door. Open up, police. Everybody knows it's police, and it's not as this structured craziness. It's police, open the door. The police are out here. Open the door. We have a warrant. Everyone knows, and then we keep banging police, and then we use the rip. So there's no question who's begging on your door, who's trying to get in, and that's when you use the RAM. So you're right. Fair. So there are occasions, but the reason why I think, and I agree with Robert, the time frame. 12 o'clock, banging on someone's door, and they banged a couple of times and then use the RAM. And now people are saying not now. You have some people saying we heard them say police. Some people saying that we didn't hear police. I'm thinking they went in. We got a no knock, but let's just knock. They knocked. Bad police tactics, right? They knock like, oh shit, nobody's opening the door. Let's just ram it, right? We got a no knock. And when they jumped the gun, now it's a question. What did they say police? Did they not say police? Was he scared? Was he not scared? Again, bad police tactics lead to bad use of force. I'll just say this: if they went in as a no knock, Breonna Taylor would likely still be alive today.
Oh yeah,
that's just the facts of the matter.
Yeah, and especially overwhelming force. You know, yeah. Not two guys walking in to see what's happening.
Yeah,
it's the combination. In other words, they created. They used the stash house, trap house mechanism for a house they knew probably wasn't a trap house. And I get, okay, we want to hit this fourth house because maybe we'll get lucky and we want to do it at the same time. But once you do that, you either have to stay with everything with no knock, with plains closed and going in fast with overwhelming force, or you've got to completely reverse course and do knock and announce and have some plainclothes people there. I mean, have some uniform people there and so forth. Because otherwise you're going to create exactly this situation. And it was put it this way. If you thought there was a chance there was a guy in there with a gun, you mean if four guys in there with a gun, those cops are dead by the way they went in there. So it's a mini miracle. There aren't more dead people here, frankly. It's a mini miracle the guy that shot back isn't dead. It's a mini miracle the people next door. There were several bullets that went through, and they however it went through, that means it's a cheap apartment building in all likelihood, not surprising, thin walls, went through the wall, went into the wall of the neighboring family and apparently out, according to what I've seen so far. So that's why this was not there's reasons why these police rules and tactics are in place. It's to avoid things like this happening. And it's very rare that things like this happen if police tactics were good.
And then I'm going to bring this comment up here. Little Rock says, is it a lawyer thing to read all these investigative reports and recording transcripts? This show is the first to mention the jail transcripts of phone calls. Did you laugh when you read mom saying, I am speaking code? No, but it might be, this will be a good time to say, well,
nobody's going to confuse these guys from the characters from The Wire. They are clearly not. I honestly was less impressed. I was like, these clearly are not big time. If they are big time people, Louisville has a low standard of drug dealer, because these guys should just watch The Wire, for crying out loud. I mean, I couldn't believe the things they were saying on the phone, particularly the dealer. I mean, that's why you hustle. That's why you smuggle in the burner phone. I mean, this is not brain surgery, folks. I guarantee you there's plenty of burner phones inside the Louisville jail. So it's less than it's a bad comedy. It's a Fargo style.
But let me keep it 100. Like when I was at both the Bronx DA's office and when I was at Brooklyn, I would say this: we had what we call Rikers calls. We had a whole division of people to just listen to Rikers calls. Now, I'll tell you from my experience, listen to Rikers calls. What I found, I've had people they confess to rapes, homicides, drug deals. They tell you where the evidence is, and there's a big sign over the phone that says this call will be recorded. Do not, it says all that. And you will not believe they talk in code. They don't believe we know what the codes are. You send it to the stash. Look, my first Rikers call, right? I'm listening to the call. They said, well, he has 2 hours worth of phone calls. Just see if the guy, it was a sexual assault. And he was like, just see if he says something. So he's talking to his friend. Yeah. So the friend's like, you did that. And the guy's like, yeah. She didn't want to give it up. So I'm like, why would you say this on the phone? And the sign is right there. So don't think criminals are criminal. They're stupid for a reason. I will say this: they will give you the whole thing right there in a handbasket on a recorded line. It just happens. It's just what they do.
The point I always make is there's a theory out there that criminals have lower IQ, and that partially explains things. And I always tell people those are studies of caught criminals. So it is definitely the case that caught criminals with poor defense lawyers will admit to all kinds of things. None of my clients ever got caught saying anything on a jail phone. Not once they were my clients. So that's all I'm not going to go further. But hey, the show Power, I mean, it's out there, folks. There's ways to handle communication. There's ways not to handle communication. And don't ever talk on the prison phone.
Question here from Robert Atkinson. Wish I could give more. Don't worry about it, Robert. Thank you very much. Do the police not use defensive hollow point ammo? How are bullets going through walls? Who's the one to answer this question? I have no idea.
Well, I can only speak in New York. They do use hollow points. So I'm not sure what they do. That's in Kentucky. I'm assuming they do because hollow points don't go. Well, they usually don't go through. Body, flesh, and I think what's it called? Not concrete. What's it called? Sheetrock as easily. But again, I'm not sure what they use in Kentucky.
I'm sure there's massive standard gaps between New Orleans and New York and there will probably not between New Orleans and Louisville, but there would be between New York and Louisville. I mean, New York, because of its experience with civil rights suits, because of all the rest, have some of the best procedures in place. But like as a civil rights lawyer, I get to always use New York standards because every other police department has access to them. So, it's the way you can prove a Monell claim, what's called a Monell claim, custom and practice. All I know is I've rarely seen a $12 million settlement before you even get to discovery. That's a high amount of money, folks. Rare. So there's something Louisville's sitting on, but they're not going to be able to keep it from the U.S. Attorney's Office. But the U.S. Attorney's Office is controlled by Mitch McConnell's, just like the Attorney General's office is. So the skeptics, the cynics out there, may say that nothing will come of it. At a minimum, the Louisville PD clearly thought that they would be able to dodge a bullet by never letting that discovery out there. Because I guarantee you Crump would have put it out there in one way, shape, or form. I'm not always a fan of Crump, but he's skilled at what he does.
Okay, I think we want to leave some mystery for Nate's video, which is going to drop tomorrow, and which will be in high definition and not the pixelated Nate that we see now, because I think Nate's on the slowest internet speed. Things are looking good in Canada. I can see all of my fingers at least. Do we want to move into the Supreme Court discussion?
Yeah.
The worst possible judicial nominee in American history?
Okay, so wait, hold on. No nominee has been selected yet, right?
No,
apparently Saturday at 5, I think.
Potential nominee in American history.
Oh, someone says thoughts on Hunter Biden allegations.
He's guilty and won't be prosecuted. Sums it up.
Yeah, that's probably true.
Hollow point will go through sheetrock like FMJ.
Full Metal Jacket.
HP ammo is meant to expand when it hits tissue. Okay, it's very interesting. And then there was one more here. Let's do this before we do this. I keep missing big chunks. I'm still at work. Don't worry about it. You'll get it afterwards. Ford seed name change. Okay. So he's going to announce. Trump is going to announce it Saturday, 5:00. I'm thinking, why would anyone announce it on a Saturday afternoon?
He's doing it so it's after he's in Miami and after RBG's funeral. I think but as it's the soonest time after the funeral and after he speaks in Miami that he can do it. So I think that's why the timing. He wants to get her through before the election. Obviously, the goal is to have a vote the week before the election. That's why it better be someone that's actually popular. In my view, I think someone that triggers a war is not going to be affirmed at least not by that time. I mean, Democrats have enough tactics to try to do something in that respect. So, but I guess that's why I thought he should announce sooner, but as a political, strategic, tactical move. I get the respect for Ginsburg. But every day he loses is a day that he has to risk winning the election in order to get her on the bench.
And so now, Robert, I see you've been quite active on Twitter about who you think he should pick and should not pick. I guess everyone's going to go through who they want, but what's the deal about? I've seen tweets about referring to tongs and religious. I don't want to say Christian fundamentalism, but referring to religion. What is the deal with I know her initials, ACB?
Yeah, so Barrett is part of the charismatic movement, related to the Catholic Church, particularly called People for Praise. Her father is one of the leaders of the organization. They have you sign a covenant, and they have very gender caricatured kind of roles, or at least that would be the left's criticism of it, or others' criticism of it. They believe in speaking in tongues. And I tell my friends that speak in tongues, remember, most of the world probably finds that a little crazy. But, send all your hate mail courtesy of Viva Frei. But that's it. So I think the secular left will be very worrisome about the sort of authoritarian religious overtones of the. She's not being criticized because of her Catholicism. She's being criticized because of the People of Praise issue, number one. Number two, she made the statement that the whole purpose of her legal career was to, quote, bring in the kingdom of God. That had Opus Dei kind of references to it that concerned some people. And the third was when she was a young, right out of law, right when her first big law review article, before she wrote a bunch of boring, bland ones, was that if a Catholic priest had a death penalty case, he should recuse himself because his obligation is first to the church and second to the court, or at least that was its interpretation. So it's that combination that has led to skepticism by some groups of people towards her. The people that are supporting her have done a good job of making any criticism along that, meaning you hate Catholics and you hate religious people. That's not.
I seem to remember something in Article 6 about there being no religious test. I seem to remember that in the Constitution.
And that's absolutely true. But do you want someone here's the way the left is, or parts of the left are going to.
Dianne Feinstein couldn't even ask the question. The question when she was asking about her, Catholicism and the doctrine being in her heart, that question was unconstitutional. The question is unconstitutional because it says there should be no religious test in the Constitution. So,
yes,
there's that.
Yeah, that there is, but here would be the counter to that. The counter to that would be that she had written a law review article saying that a judge would have to recuse themselves in cases of differences of opinion between the church and the court. And I think that that's not a religious test in my view. Now, I think you're right about the phraseology. The problem the Democrats have is that so many of them are part of the secular left now that they don't even understand the vernacular of ordinary communication, in my view. I don't understand the problem, Robert. If what she's saying is, look, I'm a person of faith, and if my faith conflicts with what I think I have to do legally, then I'm going to recuse myself. That seems like the responsible thing to do. I don't think I'm fit to judge this case because I can't render the right decision because of my conscience. So if that's what she's saying, that just validates all the more to me that she's going to make the right legal decisions. It doesn't counsel against, it counsels for. But the counter to that would be that as a senator, I have a right to take that into consideration as to whether I want her on the bench or not. And that I'm not judging her for her religion. I'm judging her for her recusal inclinations. And the way I pitch it to my friends on the right, what if a judge was an open witchcraft supporter and said that she's going to use spiritual divination with witches in order to come as a basis to consider whether she takes part in a decision or not? I think my friends on the right,
as long as when she's actually ruling, she's doing it in an originalist and/or textualist way, then that seems fine. What she wants to believe in her own time, what do I care? As long as they're coming to the right legal conclusion.
That's a very fair response. I'm skeptical of religious authoritarianism. I come from the evangelical community.
Me too.
Yeah. So, I think, and that's what it is. And so, I think that's an honest disagreement. An honest disagreement of perspectives is what we want from the court. I just don't want anyone. I don't like people that are. I don't like the hardcore sort of what I would call secular left authoritarians. It was my old argument with William Kunstler, that I believe in both sides of the First Amendment, no establishment, but freedom of expression. I don't want an establishment of a secular religion any more than a secular of any other state religion. But a lot of my friends on parts of, particularly in the Catholic world, some aspects of Baptists and Protestants, but in my experience, it's been more some of my Catholic friends. Really, I mean, some of them sometimes I wonder whether they still object to the Protestant Reformation. But putting that aside, they have a much different view of the religious church, of the church-state interaction in a way that's different than mine. And I respect that. It's just not what I want on the court.
And just to highlight one thing, I mean, I think the distinction is no religious litmus test or no religious test, but then the question becomes legitimate questioning, where someone has made their own religion part of their practice as a judge. Then it becomes a potentially legitimate basis for certain questions. And then the flip side also is if you want someone who is palatable to the mainstream population, and Trump is trying to pick someone who's going to get through quickly and without much of a battle, do you go with someone who might irk some people for right or for wrong, or do you go with Lagoa who Barnes?
Yeah. Well, on the let's move past the religious issue, because I'd like to challenge my friend Robert here on the issue of Amy Coney Barrett being an authoritarian, because personally, based on the limited review I have, and I'm not saying that I've reviewed everything you have, so you might have more knowledge than me, but based on what I've reviewed, I don't personally see it in her decisions or her writings. And the people that I tend to respect, like Senator Cruz or Senator Lee, have spoken very good about her. I saw an interview with Senator Lee, who, at least according to Senator Lee, said that Amy Coney Barrett was Scalia's favorite clerk when they clerked for them, which might, at least, well, if Scalia respected her, that's got to mean something positive. I don't really see the authoritarian streak, in that case dealing with the COVID thing. I didn't really see her citation to Jacobson as powerfully as the suggestion that you had made. So and personally, at the moment, I'm favoring Amy Coney Barrett as the nominee. So if she's truly the worst, I'm not seeing it.
Hold on, and Robert, if I may just count down the spanking that Kurt's going to get right now for evidence as to why you believe.
I said respectfully. That was nice.
All right, Robert, what do you say to that? Because I've been following you on Twitter all week. I know what you've been saying.
Yeah, so I mean, I think it's several different components of it. Part of this is a difference of opinion within the right. So there's a part of the right that, in my view, is more easily authoritarian, tends to be reflexively pro-police, pro-military, doesn't have a problem. I mean, there's a fair portion of the right that has no problem with the lockdowns. Now, from a 180 view, there's a reason why almost no major conservative Federalist Society-backed legal political appointee has received any criticism from any part of the right going back over a decade now. John Roberts was just universally praised. And so I and a few other people, now I was on the Democratic side of the aisle back then, who were skeptical, got no sympathy from anybody prominent. Harmeet Dillon and Laura Ingraham have both been tweeting out suddenly out of the blue concerns of the Jacobson case and say we shouldn't have a SCOTUS nominee about Jacobson. Now, I can tell you neither one of them is going to are willing to wage war with the Federalist Society. When I simply came out with my point of view, I was getting attacked all over the place by institutional people on the right. Even a guy had been nice to him. Not going to be nice to him anymore. By the way, if you're going to say you're a great lawyer, don't go by the acronym SHIPWRECK. Just an idea. And the reason for that, it's an unfortunate. It's worse on this part. I think is worse on the right than on the left. The left does a better job of vetting its judicial nominees, in my view, than the right. I think it's why the left has had more success. The reason is because the left doesn't have a Federalist Society. In the right, there's a reason, folks, why almost every Republican appointed federal judge either has been or is part of the Federalist Society. I don't like that fundamentally. I don't like people being part of one little group that screens out to where you can't question them, you can't second guess them, you can't critique them, you can't do any of it. And Trump made the mistake of deferring to them and coming up with his whole list. His whole list is a Federalist Society list. So it's picking amongst the bad in my view. And there might be some gems in there, but I'm not the Federalist Society. John Roberts really reflects the Federalist Society. It's a very institutionalist. It comes from what I would call, at least in Roberts' case, more quasi-authoritarian, more of an institutionalist than he is an authoritarian. But it's a side that feels very comfortable coming up with some label like enemy combatant to take away your rights so they can kill you when you're overseas, even if you're a U.S. citizen like Obama did in droning American citizens overseas. I mean, I thought we used to have a trial process in America. So I've had problems with all of this. I come from the populist, anti-authoritarian wing that joined Trump's coalition, but instinctively is independent politically. And historically and ancestrally, often on the left as often as on the right. So, I'm someone who sees Julian Assange as an icon and sees Edward Snowden as a hero. I'm not on the just because somebody's wearing a military uniform, a police uniform, or a prosecutorial uniform, or a corporate uniform, someone I should bow or defer to. And so some of my disagreements with Barrett are by nature speculative. I mean, we can't know fully what she's going to do once she's on the Supreme Court. An appellate judge is in a different. I mean, a fair criticism of my opinion is that as an appellate judge, she's much more limited and constricted in what she can do, and I respect that. But I shouldn't. My friends in the Seventh Circuit know that when Barrett's on the bench, all they got to do is look at the parties, and they can predict how she's going to rule more than 90% of the time. That's not a sign of an originalist to me. That's not a sign of a textualist to me. That's a sign of an authoritarian power deferrer to me, because they shouldn't know, oh, you're an individual against a corporation. You lose. Don't even look at the facts. Don't need to look at the law. Is it really the case that originalism and textualism is going to 90% or 95% of the time in some cases predict the outcome? Not in my view. So I've looked at over 100 of her cases, read and reviewed about 60 of them in detail. And some of this was because I predicted it going in. Some of it because I'm skeptical of Federalist Society people. Some of it is because I'm skeptical of the authoritarian wing of the Republican Party that is very well represented in the Federalist Society wing of things. And some of it comes from a long history of being experienced with the people that come from Southern aristocracy, like she does. She comes from old French aristocracy outside New Orleans. My mama went to the same school. My grandma went to the same school. My great-grandma went to the same school. I've been with those folks a lot, and I wouldn't trust them with power to save my life. So that's part of it. And some people could say, hey, that's his personal experience. That creates a personal bias. So be it. It's been very predictive for me, is all I can tell you, in both politics and law, and forecasting what someone is likely to do once they're in a position of power. And it's very rarely been good. I've been pleasantly surprised upon occasion, but far less often than would be ideal. So that's the broader perspective. The individual perspective in terms of Barrett's decision-making is that systematic bias. It would be the work that Mark Gallanter has done, the sociology of law at the University of Wisconsin, where he says, if you can predict what a judge will do more than 80% of the time just by knowing the parties, then you have a judge who's driven more by the outcome to favor those parties than you are law, at least as a likely probability. Doesn't guarantee that. It just means that once you get to a certain level where it becomes that predictable, chances are it's no longer a really an originalist, textualist, or legally or fact-driven decision. They're spinning the facts and shaping the law to make it look that way. And so that's the first overarching part. People like, and independent people, Mike Cernovich, Matt Stroller, other people have come to the same conclusion. Lawyers have told me privately that she's the closest, and these are right-leaning people who never use this terminology ever, is that she reminds them more of a fascist than any person they've ever seen nominated to any position of political or judicial power. And these are people who are moderate in temperament or disposition. And so within that context, we'll get to I think there's three of us now.
Yeah, no, I think Nate pulled himself out, but I'll bring him back in when he comes back.
No problem. I just got to move my thing around so I don't look like I'm looking at something down on the ground. I don't want anybody to think I have uncivil law and contempt. I don't. Very nice guy, very smart guy, very sharp guy. And I read your comments on the decision, on the lockdown decision. I understand where it comes from. My view comes from a different context. And so it's a threefold context. One is this broader context about Barrett and the context that I place her in and so forth. The second is reading a lot of her other decisions. But the third part is being deep in the weeds of lockdown litigation. So if you're deep in the weeds of lockdown litigation, Jacobson is the do or die case. It's the determinative case.
Yeah, I think that's right.
And for me, any judge who favorably cites Jacobson as a judge I never want to see near judicial power, period. And there, going back to Nate's question about citing I think it was before we were on live, but going back to the citing the dissents that the Judge Dickman did, I think it's pertinence, as I think Uncivil Law was right. There is no majority opinion from the Supreme Court on the lockdown yet. There's simply a dissenting opinion about injunctive relief, and one judge who says here's why he did what he did, Judge Roberts, but his opinion is by no means governing precedent. And so the question for the lockdowns is, if Trump adds a justice who agrees with those four dissenters, we now have a 5-4 that are going to strike down lockdowns. On the other hand, if he puts someone up who agrees with Roberts, it's going to be back to 5-4 pro-lockdown, unless Roberts reverses himself. And her favorable citation of Jacobson is, to me, determinative and highly predictive of how she will likely rule. And there was an earlier super chat question, brief super chat answer. Just a quick sidebar. North Carolina, I think the Democratic governor still takes the lead because they're ancestrally Democrat. So just to that super chat. But back to the other super chat question about the significance of Jacobson. For me, I have been a critic of Jacobson even before the lockdowns. To me, they're part of what I like to call the trilogy of infamy. And the reason for that is that Jacobson is used as the premise to get to Buck, and Buck is used and both of them are used as the premise, but particularly Jacobson for Korematsu. So Jacobson has been interpreted, and I don't think it can go this far, but it was used as a justification by Dershowitz, in other words, to say you can have forced vaccinations. That leads to the Buck decision, which I consider one of the most morally horrendous decisions in our history, which allowed forced sterilizations of 80,000 poor women in this country. And then the third is Korematsu, which said, you know what, if there's enough of a war emergency, we can judge you by your ancestry and just take all your rights away. And folks, it was all their rights they took away. It wasn't just detention camps. They took away their businesses. They took away their property, took away their churches, took away their freedom of expression. That trilogy of infamy deserves and must belong in infamy if we are to be able to protect the Constitution moving forward. And the cornerstone, the fountainhead, the foundation of those decisions is Jacobson. In my view, Jacobson, as Uncivil Law detailed in going through the Judge Stickman's ruling, Judge Stickman details why there's reasons to doubt its effectiveness today. A couple of legal scholars have written that as well. My problem is I don't personally believe that someone in Barrett's position did not know the debate raging about Jacobson, and yet makes very little comment aside from one sentence that, as Uncivil Law noted in his discussion of it, could be interpreted in different ways because it's kind of a bland statement. That's my problem with it. Someone like Barrett knows exactly how hot that issue is because she's seen the four dissenting judges, Justices Gorsuch and Justice Alito and Justice Thomas and Justice Kavanaugh, just go through about how it should not be the guiding light in this arena. And she made her decision a little bit before Judge Stickman did, but not long before it. And for those out there, she issued this decision in early September. Right when rumors were circulating that when she was being considered to be put on that list by the Federalist Society, the new list that Trump put out 2 weeks ago, and because he was going to amend the list to add names and maybe potentially detract them. And so to me, that decision is very frightening. It tells me multiple things that go beyond, if you're just reading the case, it's not apparent. It's the broader context that I look at it and why I interpret it this way. It's that that citing Jacobson is like citing Plessy v. Ferguson related to any issue of integration. It's like, for those folks that don't know, plus our courts created segregation in America before our states did.
But hold on, now I got to ask Kurt one thing. It's a big thing, but Kurt, I mean, who are you picking and who are you supporting, and are you as averse to Barrett as Robert?
Well, I'll say a couple things. First of all, I appreciate your kind words in this discussion, so I appreciate that. And I have not read as much on her in detailed review of her cases. So I've not read 60 of her cases in depth. And as I pointed out in my own discussion of her COVID decision, I went to some length to point out that maybe it's one of those things that becomes more emergent as you're reading for more and more cases. I thought Stickman's decision in COVID was brilliant. I mean, I couldn't have been more fawning over it if I tried. I thought it was just right down the money.
Why not?
It showed creativity and insight, and it just wasn't. It really showed a lot of intellectual heft, and I was really pleased by that. Because one of the criticisms I think you could make of the decision Amy Coney Barrett went on to is it was a little kind of banal and basic. It was a little bit just kind of painting by numbers, as opposed to Stickman's ruling, which was not doing any of that. It was like forging new ground and doing so in an incredibly persuasive way, at least to me, and all that rest of that stuff. So, the only thing that I really knew about Amy Coney Barrett going into this is, one, she's a member of the Federalist Society, which, notwithstanding its weaknesses, I'm more in favor of than Mr. Barnes is. I think it does good work and is a good organization to be a member of. And I also, heard Senators Cruz and Senators Lee speak very positively, and I know that she was vetted a couple years ago, and I know she's been on the bench longer and has more writings about her. And I know that the right is extremely concerned with, appointing another Souter or even another Roberts. Don't want to go down that road again. Mm-hmm. All that being said, I don't consider myself authoritarian. I consider myself more on the libertarian wing. Perhaps not as libertarian as you consider yourself. I mean, we haven't had detailed discussions about our own philosophies. But
you would probably love Rushing, because
Rushing. I think Rushing is the best candidate if you could possibly get her on. And then I just feel jealous because I'm 39, and why am I not being appointed to the Supreme Court?
Because for folks who don't know, she's 38 years old. But
yeah, I'm like, how's this a thing? She's a year younger than me. How's she being on the Supreme Court? This sucks.
Exactly. But she is young. She is brilliant. She is in the best tradition, in my view, of constitutional originalism that combines the different political strains out there. I think from a political perspective, Lagoa is the easy best choice for Trump. From a Supreme Court perspective, I personally would prefer Rushing, because she has some fantastic First Amendment, Second Amendment, Fourth Amendment, Fifth Amendment, Sixth Amendment decisions, willing to be skeptical of police, willing to be skeptical of prosecutors, willing to be skeptical of politicians. Willing to be skeptical of corporations. I like all of that. And I think from a separate perspective as to who any of us would like to be on the bench, I think it's critical that Trump have someone that can get through before Election Day, because he may need a fifth vote to defend the election if we get Bush v. Gore Part 2. And it sure looks like we're heading towards Bush v. Gore Part 2, except Bush v. Gore on steroids. Sorry, Viva, go ahead.
Actually, sorry, I missed a bunch of the super chats and now they've disappeared. But okay, so from my question here, I'm reading that Trump met with Barrett. Now, he met with Barrett. And there was a super chat from earlier that said, if he's going to make the announcement in Florida or Miami, he's going to make the announcement for Lagoa. My perspective, I'm probably projecting, is that if I'm going to meet with Barrett, I'm going to meet with her to tell her why I'm not selecting her in advance in person to be polite, and then make my announcement, and not necessarily meet with the person who I'm going to announce. But let's go through this. Make the predictions. Nate, what's your prediction? Hard and on the internet forever.
All right, Lagoa. I think Lagoa just makes sense politically, because you're in a tight race in Florida, and the Cuban population down in southern Florida is extremely conservative, and you have a Cuban American who you now who's gone to the Florida Supreme Court, who you're putting up. That is a win. That's a win, and that's a win in a state that he needs to win at. I think Amy Coney Barrett. I think, even though I think he wants her, but I think politically, I just don't see how you don't go with the win in Florida. It's politically expedient now, especially before an election year. Now, I do want to say, when it comes to picking judges for the Supreme Court, I think a lot of people think that what they do at the appellate level and even at the district court level is indicative of what they're going to do at the Supreme Court level. And a lot of times that just happens not to be the case, because some of the most liberal judges were appointed by staunch conservatives. Let me not talk about Kennedy, the flipper. But I will also say this: it's a different tone, I think, at the Supreme Court, because there is no you're making the precedent, right? Even though you do have some stare decisis, you can be. You can go at your own way. And that's kind of, that was like my issues with Stickman. Because Stickman, I think if that was a Supreme Court decision, okay. But now we're talking about a district court decision with mandatory precedent. And I think now, I understand why he wrote it, but I don't think it can survive appeal. I just don't think it can survive appeal, especially considering things like the Palco test. When you're talking about a fundamental liberty, there is no intermediate scrutiny, right? If it passes Palco, you get strict scrutiny. If it doesn't pass Palco, you're at rational basis. And I understand why he employed intermediate scrutiny, because he wanted to show that, hey, even if we use this lower standard, it's going to fail. Fair enough, but the test is Palco, and if he's saying Palco if he's saying that this is a fundamental right, then just say it just fails strict scrutiny. It's Palco. So I understand what Trump wants to do, and I understand. First, since it's going to be an end of it forever. First, if I was on the Republican Party, I would fill that seat. All this nonsense about what we said 4 years ago and all that stuff, throw that out the window. I don't care what anybody says. We are filling that seat. To be damned with it, right? That's just what's going to happen. And I think the Democrats trying to make any type of argument that we should say that's just not going to happen. A Republican president, that seat is just too valuable. But now I think the piece of it is that you want to put a reliable vote on that court. I don't know if the judge from Florida is that reliable. She seems that way, but is she going to be more of a Roberts, or is she going to be more of an Alito? And I now forget his name. An Alito, a Kavanaugh. I just don't know. Nate's new computer's a Kavanaugh 64. Yeah, you know what? It's funny because we just got home from a casino. We were staying at a casino, and I don't know why my internet just keeps going out and in and out and in stuff. It's because I'm the only Democrat here. I'm the only Democrat here. They don't want me to hear.
So long as we can hear you, Nate, all we need to do is hear you. Kurt, what's your take and what's your prediction?
Well, first of all, I'll take the stronger prediction and say, with respect to my friend Nate, I think he's wrong on the Stickman prediction. I think that it was well written, and I think it will survive appeal. So I'll take a strong stance on that one, because I just think it was setting new ground and doing it in a really creative, interesting, solid way, and I thought the reasoning was solid through and through. So I think it's going to survive appeal, and what's more, become a new benchmark for new decisions, because I just think that, other decisions out there have been a little bit paint by numbers, and this one is not. And so it becomes a new, precedent for other people to rely on. So there's that. As to who he will pick, the Republicans are extremely concerned with appointing another Souter, appointing another Roberts. They want someone who's going to be super reliable, super conservative, originalist, textualist in the model of Thomas and Alito and Gorsuch, and somewhere in that vein. Lagoa, I think, raises just too many question marks. And she has the slight disadvantage of having been appointed to the Florida Supreme Court by Jeb Bush, who the Republicans don't really love that much anymore. So, there's that. I think that she is too much of a unknown factor, and they feel like they have a better bead on Amy Coney Barrett. So I can't speak to the degree to which she is ultimately statist or authoritarian or any of that stuff, because my friend Barnes here has done more in-depth research. I can only really speak to, the senators I quoted earlier and other commentators that I've respected speaking well of her, and I didn't at least get the impression that she was those things, but she may very well be those things. So I think the most likely pick is Amy Coney Barrett, because I think the right as a whole kind of wants her pretty bad. So that's what I'm going to go with.
Yeah, I think a couple of things there. One is it's definitely the case the institutional right at Federalist Society is making a massive push for Barrett. And like I was talking about earlier, there is a lack of effective vetting inside the Trump White House on Barrett, because if you raise any questions, you're going to be persona non grata for any legal or political appointee position anywhere. When someone like Harmeet Dillon has to do it so indirectly, and even Laura Ingraham at Fox is doing it very indirectly, and everyone else is scared to raise it. I'll give you an example. Reason, which is funded by the Koch brothers, one of them has passed away, but still the Koch Family Foundation, which also heavily fund the number one funder of the Federalist Society, writes a piece about what a brave person Barrett has been on qualified immunity, on the only good case she ever had on qualified immunity, which was a consensus case where she was just affirming what the district court did, which was, by the way, if everybody acknowledges the cop lied under oath, they don't have qualified immunity. There was nothing brave about that. Look at the decisions where in the 40 other decisions where she said things like, it's okay to have a sniffing dog when you're doing just a random traffic check. That's just totally normal. It's okay to do it. She actually called a case a close call, which by everybody's definition was nowhere near close. A kid called in anonymously and he said, I think some people have guns a couple of blocks away around this car. And that was it. And he borrowed someone else's phone for it. And then they went and seized the car and seized the people. That's not probable cause. She was like, oh, that's a close call. Qualified immunity champion opposed to it. What a crock. But my concern is that no one around Trump, I'm literally the only lawyer on the right with any platform or profile that's raising these questions. And I'll get more crap from it than talking about Lynn Wood being a nut. So we'll see how it all goes. But I really strongly feel otherwise against her. It depends on whether Trump gets that message, I think, because otherwise everybody in Washington is telling him, as Uncivil Law said, Barrett, 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 and they're selling her as the next Scalia. If you want the next Scalia, go Rushing, because
I agree with that. I agree with that. Yeah, I think Rushing would be a better pick.
But because she had all the written opinions that like Scalia had, like Gorsuch had. Though Nate is right that a lot of times it's a crapshoot when you're particularly with either Lagoa or with Barrett, you have a bit of a crapshoot because you're talking about 1 year to 2 years on the federal bench. Now Lagoa was put on the Federal Court of Appeals by Jeb Bush, as Uncivil Law mentions, but she was also put on the Federal Supreme Court by DeSantis, who's popular with the populist right down there. I think the key though is why do I predict Lagoa? Because it's my instincts on Trump. Trump's going to sit there. One, he's going to look at pictures of the two of them. And I'm just going to say, he's going to go, that one sells well. That one,
that was never a factor that had entered my mind until you said it, Robert.
But think about it. That's how Trump thinks. I mean, that's just who he is. There's people he will not appoint if they have beards. I mean, he had to get over that for a while. And now he regrets it because he's like, man, I put Bolton on that. I knew that guy had a crazy mustache. That must have meant he was crazy. So that's just who Trump is. And he's got Lagoa. Lagoa looks good, 52 years old, the best looking justice on the bench probably ever. Just being honest. And that's the way Trump thinks. But he also thinks, but what Nate talked about, Cuban, Hispanic, first Latina. It's something that makes him look good. I mean, the daughter of immigrants, the American dream story, anti-communism that he wants to talk about. So all the thematic subtext he wants to talk about, the visual imagery. And remember, Trump is incredibly let's be honest. Trump doesn't know the difference between Rushing and Barrett and Lagoa when it comes to their jurisprudence. To him, he's like, okay, all the Federalist Society said they're all fine, so I should just pick who I want. And that's his way. I think Trump is going to be. Now, if I was right in the White House, then I could guarantee you that it wouldn't be Barrett. But I'm screaming from the outside, hoping to get a few whispers in.
So someone had asked previously whether or not you, Robert, would qualify yourself as contrarian, and I said, I answered, and I said 100%. And it's interesting that your position on the nomination is sort of anti to what the mainstream on the right is. Nate, I saw a fifth screen come up. Nate's changing to a different camera. It looks like.
Oh yeah, it's making it crisper.
Then now, so hard picks. Robert, someone asked, you're going to go with Lagoa.
Yep.
Kurt, you're going with
Barrett. I agree though that Rushing is the better candidate if Wishes made it so, but then I'd be jealous about not being on the Supreme Court. So yeah.
And then we got Nate. Who are you going with?
Nate cannot be heard.
He's still on mute. I'm glad it's you, Nate, not me though.
I got so many things going on. Lagoa.
Okay, now someone had just asked, and I brought up, I can't find it again, but it was David F. That's weird. It's not me who's asking this. Can someone do a super chat asking how likely it is we repeal Roe versus Wade after this or Trump's next term? So what are the realistic expectations or impact of the next justice on overturning Roe versus Wade? Because people are talking about it. When people talk about it this much, I tend to think it's sort of a red herring or a fabricated issue, that it's not actually going to be an issue, but people are making it one. Is it a real issue?
I think at best right now you have 2 votes at best. And so no matter who you appoint, then you're up to 3. I don't see it happening. No.
Okay. And I agree with that. The morning after pill, as that expands, really changes the dynamic of abortion. In other words, as that technology develops, your ability to suppress abortion will be as successful as your attempt as suppressing heroin. Good luck with that. So I think there's a functional part of to what degree the court can really even dictate that outcome in an everyday life. But no, I mean, what Barrett is being pitched as someone who will be the 5th vote to overturn Roe v. Wade. I don't believe she is.
Where are they coming up with 4? That's why I want to know.
Yes, agreed. That's problem number 1. So I don't think Roe v. Wade is likely to be overturned. It may be limited. In other words, they may allow more restrictions on third-term abortions, more parental consent, more restrictions about where abortion clinics can be located, things of that nature. So I think that all I know is on Monday or Sunday, I'll be either drinking in celebration or drinking in depression. So it's all going to be whether Barrett was yay or nay. But either way, I know I'm drinking.
If you want to do a live stream, to commiserate / celebrate, you know where to find me.
Exactly.
Kurt, not Kurt.
One thing I think Yeah, I'm just saying. I think the Roe v. Wade is a total fear tactic. Number one, because let's say if the Supreme Court says that principle is not constitutionally protected, most states right now, it just goes back down to the state level. So the whole thing that all that abortion nationwide would be illegal, because that's the big fear. Now, I do understand that you want to protect this constitutional right, but it is judge-made law. And I think that's the issue that comes down to it, is that you get 5 judges that make it up. You can get 5. If you get 5 judges that says, well, we're not going to accept your made up BS, then it kind of goes both ways. So I think it's a great scare tactic to motivate people to come out and vote. But I do want to ask you guys a more interesting question. I think starting to get mailers from Democratic officials talking about packing the court. Let's add 2 more. If we win, we will add 2 more. Now, what do you guys think about that? Because I have mixed feelings. My mixed feelings are, if the new rule is we're going to do what we are constitutionally allowed to do, then I think there's really no argument there, right? I think you can't then make an argument that, hey, they added 2 more seats because you're constitutionally allowed to do it. Okay, if that's going to be the line. But obviously, for all of these years, we've been having these gentleman agreements, blue slips, let's not do this in an election year, that type of thing. But if now all of those rules are off the table, court packing is a real possibility. Now, do you guys think that? Now I am, just to be clear, I am 100% against packing the court. I believe packing the court is wrong. I believe if the Senate, who's ever in power in the Senate, Trump got lucky with 3 picks. That's something that you can't overturn. But I think when you talk about now packing the court, but that is what the Democrats are now running on. If we lose this pick, we will add 2 to the court. How do you guys feel about that?
I sort of have a mixed sentiment. One is, my view is, if the basis was a legitimate basis of concern that we have courts that were designed for 1960s dockets, not 2010s dockets, not 2020s dockets, then I would understand that. But my recommendation would be then do a compromise. Both parties get to equally nominate, no matter who's in the majority. So say we'll agree to 150 additional appellate and district court judges. You get 75, we get 75. Because then that would show me the concern was not a political power grab, but was a legitimate concern that judges are handling far less effectively their dockets than they were in the 60s and 70s, because we have not kept up with the docket size being proportionate. The other thing is, if they were to propose a rule that would change moving forward the number of judges according to the docket size, I would be open to hearing that argument, because as a lawyer who sees the problems with that every day in court, I don't have a problem, because increasingly we have a law of the clerk. We have judges who are issuing decisions that their clerk are drafting. And, in Judge Sullivan's case, it might be because he's not the brightest bulb in the block. But for other judges, that's my additional insult to Judge Sullivan. Hope I'm never in front of him. I'll take it all back. A different Robert Barnes said it. I was drunk at the time. The Canadian gave me some sort of thing over the online. I was thrown off. But there are some other judges simply because of time and opportunity. They are way too stressed. I was in front of a judge in California today. Now, this is a state court issue. They're he's like, yeah, I can give you a motion hearing in 5 months on a basic motion. It's like, this case isn't going to get done for 5 years. So I am concerned. I do think from the conservative side, the fear is the Democrats want all the power tools. Add DC and Puerto Rico as states to stack the Senate. Change the old appointment agreement of the 1920s about the House and increase the number of people in the House so we can increase the number of Democratic votes in the House. Do the same with the courts. Stack the Supreme Court, stack the Court of Appeals, stack the district courts, and then grant amnesty to illegals. So we change the whole voting structure of, say, Texas, Florida, and other states that might be impacted by it. So I think that the conservative fear of that, and unfortunately the left has, at least in my view, played into that the last week or two. When I see left legal scholars saying, yeah, pack the court. I was like, that's unpopular. That was even unpopular for FDR, folks. And that was during the Great Depression. That's not a political winner. That's just going to scare people on the right. If you have a legitimate reason, use that as the basis, come up with a reasonable basis that's tied to it. Something narrowly tailored to a compelling public interest, not something that's just a rational basis.
I mean, I got 2 questions, because the court packing seems to me like it doesn't just seem like mutually assured destruction. It just seems like destruction, because I don't even know if you consider yourself a Democrat, how you would support that, because you know what it's going to lead to. But two things: can you prevent court packing through some sort of legislative means, or can you limit the number that you can pack it to through some legislative means? Is there any way to control it?
No, there's no way, unfortunately, to control this. And I have on my channel expressed concern about the long-term implications of appointing someone, and what will happen in the future, because I'm concerned about the solvency of the Constitution. And that means being concerned about the solvency of the structure, solvency of the three branches, the separation of powers, the solvency of federalism, and all that good stuff that, people who love the Constitution believe in. And I'm less concerned with other Democratic proposals on a personal level. I don't think the filibuster should be a thing. Haven't thought the filibuster should be a thing. If the Democrats want to get rid of the filibuster, that's cool. No problem. I think 51 votes should control no matter which party. Totally down for that. That's fine. Packing the Supreme Court, though, oh my God, I don't know. I don't know how that works, just on a practical level. Because if you up it to 11, I up it to 13, you up it to 15, where does this end? And it becomes, and one of the things I'm concerned about is trying to keep the legal branch separate from the political branch. I'd like to do that as much as I can. And now you're turning into an even more overt political tool. And what that does just for everything. And there's no way to limit it legislatively. Congress can increase it anytime they want. It's been 9 since 1860. It's been this number for an incredibly long time. And it is so, one of the things I said on my own channel is if I were Trump, I didn't know what I would do, because I'm trying to think about long-term political implications, but I don't think anyone's thinking those ways anymore. So I think the Democrats probably are going to do it. And at that point, I become really concerned about what's next for our constitutional republic. That's how afraid of it I am. Bad omens.
It seems just terrible for, I say, optics, and I'm just going to bring the super chat out. Optics and just in terms of not getting your way, bending the rules, or abusing the rules or exploiting the rules, as though you would expect the other party not to do the exact same thing if and when they take the power to do it. It just seems disastrous. And if I'm a Democrat and I see them doing this, I sort of cringe, because it's not an alluring option. I'm not saying I'm a Republican. It's just if I see anybody saying, if you do what the Constitution allows you to do, we're just going to try to negate it through some sort of, I don't want to say sneak rules, but we're just going to negate it when we come to power. It doesn't make anybody look good. It doesn't make them look good. I'm not going to play that equating stuff. It looks bad. It looks bad from the way I see it in Canada. And yes, whoever said Canadian, I am Canadian.
It is. Don't get me wrong. It is bad. It's bad because they're making it seem like Republicans have broken the norms, but I really don't think they have, right? If you have we all know, if you have a majority in the Senate and you have the opposite president, you're not going to nominate this pick in the final year. That's political suicide, right? And then if they're aligned, you're going to, it just makes sense. But I think the tool now to use is that, hey, we need to throw the base some red meat. And the red meat is, hey, they can get this one, we'll get this too. That gives people hope, that gets people out to vote, and that gets people thinking about, yes, let's get Biden in. And now I think that's why I think Trump is going to go with Laguna, because I think right now, if that's the plan for the Democrats, hey, he can have this one because we're going to get you two when he's out. It's going to get harder to get that one if we bring a Florida Cuban and get that base riled up to vote, because they want to keep that, and that helps that may not help you in the Senate because those senators are not up, but that does help Trump because he can't win without Florida. He cannot win without Florida.
I'm not sure appointing Lagoa makes it less likely for there to be court packing in the future. Not really seeing that myself. I think Orange Man bad, and therefore Lagoa bad will win the day.
No. If he keeps the presidency, you can't pack it, right? Because you got to sign on to it, and you need.
Not today, but not maybe tomorrow. I mean, when I'm talking long term, I'm talking really long term. Well, you thinking 20 years down the line, 50 years down the line. About these implications.
William Collington says anybody that would accept court packing appointment would be exactly who should not be on the bench.
Every single one will take it. I mean,
that's right.
I was watching.
I would take
I
it.
do it. I do it.
You're gonna point me. I'd go.
Yeah, that's right.
Well, and maybe that's the ultimate solution. Maybe we democratize the Supreme Court and we let all 200 and 300 million Americans be members of the Supreme Court, and we just submit all issues to mass e-voting.
No,
The Supreme Court becomes the people.
Make Twitter mandatory and have trials on Twitter, and you have your tweets, thumbs up, thumbs down.
Yeah, exactly. I think to Nate's point, one aspect politically is for the Senate, for the Republicans to hold their seat, someone less controversial like Lagoa probably helps Collins, probably helps Gardner, probably helps McSally in those really tough, close seats, more so than Barrett does. Barrett probably causes more division. And unless the goal is, I like Collins would be stuck in a tough position if she were to have to vote against Barrett. Because for people who don't know, Collins is openly pro-choice. I mean, she's never made a bone about that. She loses her base in Maine, but gets some other. I mean, it'd be so. I think for those senators, Murkowski as well to some degree, though she's just iconoclastic. It's easier for them to vote for Lagoa because 27 other Democrats already voted for a year ago for the 11th Circuit, whereas nobody on the Democratic side voted for Barrett or Rushing. Rushing would have the same problem in that sense. But I think that's where it is. It is a long-term issue. We'll see how much it's a Democratic real desire to just use power for its own sake and pack everything. I think they regret right now that they gave up the filibuster for judicial positions.
Yeah, I'm sure they do.
We'll see what they do.
I think they regret something else, and this is a point that other people had brought up a little while back, that RBG could have retired before Trump got elected and had someone appointed in her stead that would have had a longer lifespan, and they didn't do it. Some people were saying they didn't do it because they thought Hillary was going to win and they wanted to have a female justice and a female president. I suspect I know what all of you are going to say about this, but what is your take on the dying wish argument that the media has now been promoting for
lame? So lame. I mean, I didn't need to be told that's what Ginsburg would want. Of course, that's what she want. So, like, when they said this is her dying wish, I'm like, you didn't tell me anything I didn't already know. Wow, what an amazing concept. I'd like to be appointed by a president who's going to appoint someone more ideologically aligned to me. Couldn't have seen that one coming. Geez. So, yeah, this dying wish doctrine doesn't make any sense. The dying wish, like, you knew that, right? You didn't need to be told. And the idea that like it should be meaningful, it's not her seat. She was just sitting in it. It doesn't belong to her. She can't will it.
People's seat.
I remember I did Will's Trust in the State. Don't remember the I can will the Supreme Court seat at part of that lecture. So no, I don't see that working. So yeah,
and this is one of the arguments I had with some of my friends who are far left. I honestly said, we deserve what's happening now, because I think it was selfish for her to understand you're up in age and understanding you're taking a hell of a risk, right? Because you are a liberal vote on a 5-4 court. Losing, you have a chance to go out on top, and just say, hey, and Obama's going to appoint another lefty and you're going to be happy and go up. Instead of just doing that, now you're 87 on the Supreme Court, holding on every particular day. I think for all the great things that she did accomplish, I think the selfishness to stay on the court for those 4 or 5 more years that she made it on, now it's put her into a bind. Now I think the whole thing about my dying wishes, that the next no, you don't get that. You don't get that. If you wanted that, you should have done that early in Obama's second term when you had the chance to do that. Now you can't now say Trump and the Republicans can't. Your seat is not up for grabs because it's not up to you. So even me, someone who doesn't want Trump to appoint anyone, who would rather have the people vote for this seat, I'm just being honest. I think the death wish argument falls on my ears are death. It does not move me either way, because she had the chance to do it and she wanted to grab that power to the last possible minute. And, with great power comes great responsibility. She messed up and now her seat is going to the person that she didn't want it to go to. That's just tough luck. And I know that sounds cold. I love RBG. I think she was one of my favorite justices. Yeah. But the truth is the truth and the facts are the facts. It's not your seat. It's the people's seat, period.
My view is that if there's riots in Michigan before Election Day, then my lefty conspiracy friends might have something going for them. Now some of these are folks like Dan Aykroyd from the movie Sneakers, which, man, that was a long time to
that was a
reference
great movie. I love that movie.
Yeah, absolutely.
Damn, you aged yourself there, though, bro.
Yeah, I did. I love that movie. I watched it repeatedly.
Bill Kingsley, man, crushed it.
Exactly. Well, in it, he's explaining how Eisenhower cut a deal with the aliens to give them all the cow lips they need. And some of my lefty friends come from that perspective, but they were predicting riots in all the key swing states, plus RBG would magically die before the election. So, maybe her last real words really were "Orange Man bad." I don't think her last wishes are controlling, of course. So I think what she should have done, she wanted Hillary to replace her, first woman president, to replace one of the first Democratic woman justice. But she should have what she could have done is created trouble for Republicans by, as soon as Trump winning, saying she was going to step down, and then Obama might have had enough leverage to cut a deal where they would get to do Scalia's replacement, but he would get to push through, and even could have tried in a recess. I mean, Eisenhower did it. Some other people have done it to push that replacement for her. But I think her ego is too big. And I think that's part. I think she wanted to hold on, hoping finally Trump would lose and she'd have a Democrat replace him. And she obviously was on the wrong side of that gamble. And the media clearly was hiding evidence about her health, in my view. Right? There's no way your whole family knew she was going to die, yet nobody else had any clue she was in any serious problems.
We had discussed this last stream where, there was a talk on the internet, have you seen RBG in the last little while? And there was a moment where there was a picture of her taken at some show back when things were open. My only observation on this dying wish argument is that what my major problem, in as much as you could respect RBG for her life and her career, she got politically proactive, and she on the bench when Trump was getting elected. And I said at the time I wasn't really talking about this stuff, but some of her tweets as relates to Trump were not things that a Supreme Court justice should tweet, even if it's what they believed. And she got activist on the judge in terms of Trump's reelection. And it's almost like now that, setting aside the fact that I don't think it's nice to exploit someone's passing and create some sort of unrelated obligation to someone's death, which you mourn in any event. I don't like that aspect of it. But it's almost like activism from beyond now, where she didn't want Trump to get elected in 2016. She made a bunch of tweets about it, made it very clear and vocal, which I don't think she should have. And now people are leading us to believe that her last wish was more judicial activism in terms of how the Constitution should be interpreted. It looks bad just from every perspective. And I don't care if you're left or right. It just should look bad to everybody. Wow. And they ram it down your throat in the media. Like it went from being an incident to the main narrative now, from CNN to MSNBC. And it's
maybe someone can tell me one of these days why interpreting the Constitution as it was written is such a controversial idea. I thought maybe laws, when they're written mean things, and once they're passed, they continue to mean that thing over time because the meaning didn't change over time. And so therefore the Constitution should be understood as it was written. I don't know why this is such a deep concept.
Hold on, Kurt. You are not even an originalist anymore. You are a textualist. I'm hardcore
textualist, yes. Baby. Text, baby. Whoa.
He loves the Gorsuch decision.
Gorsuch, baby.
And Gorsuch was nothing but textualism.
Text, baby.
Again, because it was funny because me and Kurt had an argument about Gorsuch's decision in the what was the name of the case?
The workplace case. The gays in the workplace case.
Yeah. And how now there was a battle between textualism and originalism, because originalists they actually put in the LGBT and it was specifically left out. They were like, no, we're not protecting these people, but we're protecting this. So originalists would say, hey, let's and that's what Kavanaugh said. That's what, but Kurt was like, no, I'm straight textualist to that.
Originalism is old and busted. Textualism is the new hotness.
Yeah, Gorsuch is the new hotness.
The intellectual conundrum is that I agree with Huey Long when he said he wanted to make the words read in the language they were written in. So people can figure that one out, because that will sound like a contradiction, but it's not really from an old Southern populist tradition.
But you agreed with Gorsuch's take on it, because right? Yeah. So because I
little d democratic principle. In other words, I think Congress can fix it if it's a problem. And how it's written is how it should be. Now, my Sixth Circuit Covington case, it didn't matter that a lot of things weren't inside the statute. So the left's argument or other people's argument would be, even textualism and originalism is always part of a debate as to what it really means. And there are some fair criticisms of Gorsuch that says that though I agree with Nate, the main criticism of Gorsuch was that it was a non-originalist, non-legislative purpose interpretation, and that the textualist interpretation was stronger in favor of how Gorsuch did. But there are some friends of mine on the right who disagree that the text would require that conclusion. It's the old eye of the beholder. Originalism and textualism sounds great depending on what you think that originalism and textualism means. And there's some truth to that. The old school of legal realism that judges tend to, you can tell a judge's decision by what they had for breakfast in the morning. And there was some aspects of that going back to William Orville Douglas and Hugo Black. But I like the textualist principles definitely and originalist principles because they're little d democratic principles. I want people to have most of the power as much as possible. I don't trust elites in any form, whether they're wearing black robes or any other uniform.
I always say this to the people on the left. I said, you guys are originalists when it comes to the Second Amendment, and then you guys all of a sudden flip to progressives when it comes to abortion, right? It's like, what does the text say? What does the text say for the Second Amendment? It doesn't say that. It doesn't say that. So I think you're right. It's a beauty is in the eye of the beholder. It's whatever those your political.
Well, at least there is a Second Amendment. I don't remember the amendment dealing with abortion. I've read my Constitution a couple times.
Hold on. Every time you say that, I always bring up: is that an exhaustive list of rights in the Constitution? Is that an exhaustive list?
If it's Judge Barrett, you don't have any of them as long as the governor says lockdown.
Actually, one question someone asked before, Robert, I think we discussed it in our last stream. As far as all three of you are concerned, the SCOTUS pick, who is going to be the best protector of Second Amendment rights, would be whom?
That's an open question, but the best record is Rushing. So
Rushing.
the Rushing has the best clear record as to where she is intellectually on all the constitutional issues. You can make an argument for Barrett. She dissented in a decision where she said that felons should not lose their gun rights just because they're felons if they're non-dangerous. But there's a fair amount of people that there's people on the left that actually share that opinion because they don't like all the restrictions on felons that don't relate anymore to their sentence in their view. That's part of the fine argument that we're creating these extensive permanent sentences. In fact, originally it was the argument against sex offender registries because like all of a sudden you're retroactively changing someone's sentence after the fact for life. But I mean, that is an argument in Barrett's favor on that one, that she does have a Second Amendment case she can cite. I don't read a whole much into it because it's a limited kind of issue. In other words, should in the sense that she's recognizing the Second Amendment would have an impact on the statute, that has bearing. But where it leads, whether it goes beyond Heller, that's sort of more of an open question. When the earlier super chat was asking what decisions might the court take, clearly, by the way, there aren't 5 safe votes for the Second Amendment, or they would have taken a bunch of good ones over the last.
Roberts is the one holding it back. I know he is.
That's why whoever this new one is going to dictate whether those get taken or not, good or bad. But it's going to be the magazine cases that we've talked about. That is heading up to the Supreme Court, and it'll be up to the Supreme Court whether to take it or not, and we'll see.
All right, now I'm going to pull this up. Phantom Hive, I'm not pulling this up to put you on blast. I've specifically said this in the beginning. I can't get to all the super chats because it will not make for a stream that will be viewable. It'll just be super chat interrupting all the conversation. So I bring them up to thank you, but I cannot get to them all, and I do my best. So,
and you should absolutely super chat. You're being nice. You're being complimentary. You're helping support Uncivil Law and Nate Lawyer and Viva Frei. So so do it. Be right. Be smart. Be courageous. Be conscientious. And then just because he doesn't get read doesn't mean we don't read it at some point. I mean, I even go in and talk to comments now and then, even and accusing me of all kinds of things.
I can tell you, Robert goes back and reads things. I read them as they happen, and I suspect other people read them. Even the hurtful comments, we go back and we read, and we cry ourselves to sleep at night. Except for Robert, who has.
I saw a couple comments against me already in the chat. I tell you. I saw everyone, and everyone hurt me in my heart. I guarantee you.
Oh no, Nate! Yeah,
there's been some surprisingly harsh, No, I was going to say, there's been some surprisingly harsh ones to Nate and Kurt and Robert. You'll go back. You'll see.
Oh yeah, I've no doubt. Well, especially once I jumped in the Barrett thing. But of all these attacks with people saying, "I'm not going to listen to you Bloomberg writer," and I was like, if you can't even read a short Twitter bio, that's where Bloomberg News is complimenting me. I never have worked for Bloomberg. Mini-me Bloomberg has never been my client. Then you really shouldn't be in a place to criticize. It's like being a lawyer hiding behind an anonymous account named Shipwreck. and telling people what to think. So at least have, I respect any really smart satire, any good sarcasm. I'll respect. A good little pot shot is okay now and then, but at least have enough intelligence to make it self-respecting.
Oh, and I'm going to read this one just so everybody knows. We've discussed this multiple times in the past. YouTube's cut on Super Chat is 30%. PayPal is the better way. Patreon's a good way. But that's the that's the nature of the beast. So it's just so everybody knows. Okay, if we have a dwindling amount of time, do we want to talk about stickmen, or does someone want to suggest something more, I don't know, new?
Well, by the way, do all of you guys have, you probably, Viva, give out people's Patreons or whatnot, or will that be in the description below?
I will put in everyone's info. Barnes, Robert, I always put yours in. This time
I'm okay. So everybody else should get support. I mean, everybody on here does a lot of effort. I don't. I just show up and yip. But everybody else on here does a lot of great efforts to build channels, build information, educate people, inform people. You can disagree and debate, but in an informed and gentle way. And not be dramatic about it. So people should support everybody else because they're doing very important legal education, particularly in a world where, people don't know the accurate facts about simple cases like Breonna Taylor simply because of how biased our media is.
Like any of the cases, even George Floyd has been completely been misrepresented. So, I mean, the case is more complex when you actually go and look at the factors, and you're like, well, here's some evidence that you don't know about.
Well, this is the problem, is that it may not ultimately change one's perspective. I know the way I underlying feel about what happened in Floyd. I know the way I underlying feel about what happened in Breonna Taylor. But when you learn these facts that are not being told to you, your initial reflex, and it's an understandable one, is to pull harder in the opposite direction and say, there must be something more to this, so I'm not even going to believe what I might otherwise believe had they just given me the facts and reported responsibly in the first place. And then you start to think that the media itself is trying to do something. I'm choking on my own tongue here. That you believe that the media is not only doing their job badly, but they're doing it deliberately badly for other nefarious purposes. And so every day when I hear Brian Stelter, every day when I see him and hear him talking about erosion of the public trust in Trump, trying to undermine the election results, trying to erode public trust, they know that is exactly what they're doing. And you cannot help people believing that when you start to learn facts in Breonna Taylor that everyone's going to learn from Nate's video, and George Floyd, which nobody knew at the time or which were not disclosed. You cannot blame people for believing that once they learn the facts.
Someone has to explain to me why the media is trying so hard to increase division and polarization. I mean, they're doing yeoman's work to try to make us all hate each other. And someone has to explain to me why.
Dog bites man.
Is it because anger spreads and it's just for the clicks and the ratings? I mean, that's the easiest explanation.
I think that's half of it. The other half of it, I believe, is that there are those who support. They think it undermines Trump generally. But the other factor, I believe, is, for BLM, this is their goal and their objective. It goes back to the old socialist, Marxist, liberal debate. The old Marxists believed that the what they would call the liberal, the establishment liberal, was the biggest hurdle to real change.
Yep.
And this goes back to the Cuban Revolution, the Soviet Revolution, the Mao's Revolution. That's why he did the Cultural Revolution. It was the old loyal. Mostly old loyal Chinese communists that he had to young people throw out. So it's an old mindset that says, what's holding back utopia? It's this old liberal institutional order, and we need to destroy it. And how do we destroy it? We destroy it with divisive cases. The more division that unites, that could give us destruction, and only by destruction can we have utopia. I think.
Should I point out that utopia literally means nowhere?
Yes, no doubt about it. I think one good last question to wrap up on goes to an earlier super chat. What everybody thinks about the probability, we can give a time frame on it. What's the probability that before the election, Durham brings meaningful indictments?
I think zero.
I saw an article in Fox which seemed to indicate that serious stuff was coming because they're investigating the Clinton Foundation.
I think this is a very dangerous game to play, especially when you're talking about law enforcement. I think right now, from 2016 to now, my problem is the media has now been weaponized against Trump, and I can say that clearly, and I think also the media has been weaponized to make people emotionally invested in bad information. And we can start with everybody with the Brooks case, right? The Brooks case, the cop was, someone pointed a taser at a cop and a cop responded with the appropriate level of force, even in their own policies, and they charged the cop with murder. So things like that. And even with Breonna Taylor, they tell you that she's, this is someone who was innocent, who was this, but not understanding that it's more complicated. Now, I do understand, like in George Floyd, there may be some facts that are out there that I do not know. But I'm saying, if there's a fact that they're going to change my opinion, I would want to know that fact, right? I would want to know that fact that would change my opinion. But from what I'm seeing now, it just seems like the media is wholesale hiding facts that they just don't want people to know. Like, most people don't know Breonna Taylor was questioned on a murder charge. Most people don't know that they believed her house was stashed. Most people don't know any of this fact. Yeah, no one knows any of this stuff. Yeah. Why? Because the media is specifically not telling you. And these facts they know.
Driven snow.
Yeah, they know.
The driven snow, except for her house being used as a drug den.
Yeah, and the sad part about it is that most people will probably come out to the same conclusions anyway, that, hey, maybe they shouldn't have done the no-knock warrant the way they did. Maybe if they would have just, rammed in and done what they're supposed to do, maybe no one would have been killed. Maybe we should change police policy. These ideas could come naturally, but by them trying to force it down our throat, and then when you find the truth, it makes you rebel against them. And that's the problem.
I mean, there's all kinds of legitimate questions to be raised. I mean, we could have a legitimate discussion. We could have a legitimate discussion about no-knock warrants. We could have a legitimate decision about qualified immunity.
Let me say this one thing. I was just at a casino, and I had two black people next to me. We were playing poker, and we were talking about BLM and all this other stuff. And they were like, "Yeah, we're going BLM." So they asked me, right? They asked me about Robert Blake. They said, "What do you think? What do you think?" And I said, "Well, do you really want to know what I think, or do you want me to tell you what I'm supposed to think?" They're like, "No. What do you really think?" I said, "I would have shot him. If I was there and he's reaching in the car and I don't know what the hell he's reaching for, and I got a gun on him, stop reaching, stop. I'm pulling his shirt and he reaches in. It's between me and him. I can't afford, my kids and my wife can't afford me looking to see what he pulls out that. It's just not going to happen." Yeah, and you know what? And you know what those people said to me? They said, "Nate, I would have done the same thing too, but I'm afraid to say it." And that's the part that, and these are black. These are two black elderly people who are seeing and saying, and they saw it too. And that's what I'm talking about. It's the fear of just giving your opinion, because if you do, then you'll be cast off the island, and that's the problem. Go ahead. I'm sorry if I cut you off.
No. Well, I was going to say, you're going to get people saying that, when they don't think anybody's listening, and there's not going to be some massive backlash. And then the flip side is the people who do the backlash are going to say, "I don't care if the cop hesitates and he suffers. I don't care, because they sign." I read people making comments. They signed up for the job. They knew the risks they were getting into, as though that's like the most simplistic way of writing off what would be a justifiable response. But no, it's an amazing thing. Like, I have these discussions with people on the street when we start talking about what I do, and you get the feel. First of all, you get the feel for the land publicly based on comments. And when you have these more civilized private conversations, you get the feel for what the silent majority really thinks, notwithstanding the media hype trying to tell them what to think. And I share the same experience in a number of throughout demographics, through conversations that I have with people on the street. It's an amazing thing. Oh, and hold on. We got Kevin De Silva asks, I ask again, can media be charged criminally? It's not about ratings. If they were pro-Trump, they'd have 10 times the ratings. I don't think they would have 10 times the ratings, but Robert, Nate, Kurt, I mean, I think I know the answer. What would it take for the media to be charged criminally for spreading misinformation?
That's a good question.
A miracle, because it's not happening. They're constitutionally protected.
Yeah, anything you're running into is like
the Alien Sedition Act.
Basically, sedition was the one I was thinking of.
Yeah, the Alien Sedition Act, right?
Is like trying to ferment this active misinformation. If you could show the intent, I wouldn't want to be on that prosecution though, because
before criminal, you'd get defamatory. If that, and even that's important. Yeah, and that's based on civil standards, not on criminal standards. So it's key. We can all wish. It's not going to happen ever. But someone else asked a question, and it was Kay Scott, I believe. It's a good one to get to. Who is the worst? I assume we're talking the Supreme Court nominees for mandatory vaccines.
Barrett.
I can't disagree with that because of all the nominees that are being floated. She's the only one, to the best of my knowledge, who's cited Jacobson, and she did cite it with some favorability to the extent that what she was really trying to say there is an open question. But I can't disagree that, she has the most against her on that.
I'm going to bring this one up. Real Bambunga says, what I've never understood, and we're getting back to Blake now, is the argument this person deserved to die for going to his car, as if deserve has anything to do with it. Well, okay, plugging Nate. Nate did the best breakdown of this, which you're ever going to see, which PolitiFact could, learn to watch and actually get facts, where PolitiFact says, we don't, there was a knife found in the car afterwards. There was something in his hands. We don't know what it was in his hands. It could have been sunglasses, except we heard the cops say drop the knife. We heard bystanders say drop the knife, but we don't know if the knife found in the car was it. Nate did an amazing breakdown and explained from a legal police officer perspective, from a lawyer perspective, everything. But
you know what the problem is? It's the fact that people will die in these situations, but no one. I'm not saying Breonna Taylor deserved to die. That's ridiculous. I'm not saying I'm not saying any of these people deserve to die. What I'm saying is that the situations that presented themselves, unfortunately, led to these people's death aren't sometimes criminal. They just are not. And the same thing in Jacob Blake's position. He didn't deserve to die, but those cops didn't deserve to die either. And use of force is not about what actually, if there was an actual gun. It is about the threat of force. It's like suicide by cop. Someone will come up to a cop and say, I have a gun and I'm going to kill you, reach into their pocket. That cop is going to shoot them. And if you find out the person doesn't have a weapon, oh, why didn't the cop wait? Well, if the cop waits and that person does have a weapon, then that's a different situation. And that's what people have to understand. It is the threat of use of force that cops are afraid of. And Jacob Blake, no matter what anyone can say, when the cops are saying, do not reach, do not go into your car, and he reaches, he could be reaching for a knife, nobody knows. And a cop is trained to stop the threat. That's a threat. And if you think that you can go in that situation and do it differently, then put on a uniform and hold the post, because I think you're full of crap. It's just that's just the way it really is.
Someone had said what was another topic that someone had pushed, recommended before we go? Kurt, you pick something. What do we do? I'm going to see if there's another comment that says what we can talk. That's suggesting something. There was one that I had on mind. Okay, before we get there, sticking it to Stickman, or going back to Stickman, who's making a prediction on whether or not that decision gets overturned in appeal?
Affirmed.
I believe it will go to the Supreme Court if Trump picks the right Supreme Court nominee. And if he picks the right Supreme Court nominee, it will get affirmed at the Supreme Court. I'm not as confident. I'm not as sure. Third Circuit's a roll of the dice. Depends on who you get at the Third Circuit. It all comes down to who he puts on the Supreme Court, as to what, in my view, because I think it is a natural Supreme Court case. If you're against the lockdown, it's the best case to take up to the Supreme Court, because it's the best factual record and best legal arguments explained by Stickman.
Yeah,
Great name, by the way. I love the fact the guy's named Stickman. I just love it.
Stickman. Yeah, stick it to him.
Yeah. I think it's overturned on appeal. I think you could get a win in the Supreme Court, because that's where you change the precedent. My argument with Stickman is really twofold. Number one, it's the district court level, and I think he's trying to make new law, and I think the arguments are good, but I think he's using, unfortunately, when you're using the dissent, and then you're trying to. I understand what he was trying to do with the application of scrutiny. But I think you can get them on technical matters at the appellate level. Mm-hmm. And then I also think you also have the other issue of dynamically changing pandemic, and the government's authority to make these rules and provisions are at its highest level. So those restrictions are definitely going to be really, really scrutinized at, I think, the appellate level, even at the Supreme Court level, because let's not forget, if you're saying that this unelected judge, who's not beholden to the people or the political branches, can now second guess officials who supposedly have this, requisite knowledge and degree. I think that, and those are the words of actually John Roberts in his concurring opinion. I think it's just hard to uphold that ruling without more. I think the Supreme Court can do it, but I don't think the appellate court will have the balls to uphold it. It just would go against too much precedent, and you have too many other rulings out there. The Illinois ruling, the California ruling, and you have these other even local court rulings in Pennsylvania that this goes against, right? State courtroom. So I don't know. I don't know how
at least for me, I thought the district court did a very good job distinguishing all those cases and showing why the posture was different. The other Pennsylvania cases, one hadn't come to a final conclusion. One was a TRO, so that's more skeptically reviewed because it's more blind.
Temporary restraining order for anybody who doesn't know.
And looking to these other decisions out of Kentucky that kind of went the same way. So there's some good authority out there. And I thought he did a very good job of piecing it together. And with respect to my friend Nate's analysis, I thought the intermediate scrutiny stuff was really good too. I thought that they did a very good job of trying to analyze it and even did some rational basis review and showed why some stuff didn't even pass rational basis, because you can't come up with a reason to do this. And I thought there was some good stuff there. So I'm going to go with affirmed. And if the court reverses, then we will definitely read that case and try to figure out what the heck went wrong.
Robert, what do you say?
Oh, just the same thing. I think it's a natural SCOTUS case. And so if it goes to the Supreme Court, it all depends on who Trump nominates.
Okay, so I hear footsteps, but there is one that I actually sort of want to make sure I understand from my own perspective. The Florida Bloomberg felon issue.
Not a crime. It's not a. For those who don't know the background, it's Bloomberg is offering to pay off people's fines because right now, because of a decision issued in part by Judge Lagoa on the 11th Circuit, until you pay off your fines, you haven't served your sentence, is her interpretation of the Florida law, and consequently, you cannot register to vote, despite the changes the Florida legislature has made to permit felons to vote. And so Bloomberg and now LeBron James apparently are promising to pay off everybody's fines so that they can vote. Now, it would be problematic if they put any conditions on that. If they say you have to vote in exchange for me to pay off your fine, that would be illegal and criminal. So Bloomberg better just get out the checkbook because he really should, in order to be legally safe, he should pay everybody's fines. If he does anything different than that, he could get himself in hot water. The Florida Attorney General has already referred him for federal prosecution or investigation because they think he will cross that line. It's Bloomberg, the guy's got, he's used to doing whatever he wants. So I think he will not be dumb enough to cross that line. Now, LeBron James, don't be sitting there with the Malcolm X book and not know what Malcolm X wrote. Don't pretend to have read the book, my friend. There's a lot of great wisdom in that Malcolm X book. That's something else that probably surprised some of my conservative listeners, but I was a fan of X. He was a big Second Amendment guy too, folks. That's my short takeaway on Bloomberg.
I just brought that comment. Yeah, it's a wink, wink, nudge, nudge. Like everybody knows what is being said, even if it's not being said. And that is the nature of corruption. And now that you mention it, one last question before I get swamped here. Department of Justice investigating Pennsylvania, Michigan, New York for the nursing home deaths. Does that go or does that not go anywhere?
No, I think that does go somewhere. I don't think they'll go anywhere criminal, but I think they're going to, they want that to not happen because the problem is all three states went ahead with those policies after the CDC had issued specific directives otherwise. So that's, they are in some trouble there. I don't think it'll necessarily reach the gubernatorial level, even the governors. There's evidence against the governors. There's not a history of that happening. Usually they try to bring reforms. My biggest problem is those governors went and immunized the nursing homes after the fact. So I have potential clients of mine too, and I have problems with that. I was like, you're creating a circle where nobody's immune for killing people by their negligence or recklessness. But I don't think I think they'll try to do something so it doesn't happen again. But I don't anticipate it going to a high level criminally because unfortunately there's just not a lot of evidence of that unless you help Donald Trump get elected president.
And it's amazing. It's an amazing thing. And I put out a tweet on it because we have the same problem here is, the policies, literally the policies, because they lock down the healthy. Think what you will about that. By locking down the healthy, you sort of had a limited amount of staff working at these old person homes. There was even something more serious in Canada where they had unlawful people working. And so they were being shifted around without anybody knowing. So they're infected going from one nursing home to the other. 80% of the deaths in Canada result from nursing homes. In Pennsylvania, it's 68%. And then you have the governor imposing these lockdown measures on the non-problem and therefore never going to find a solution to the actual problem. When I found out that the Department of Justice was investigating, it's like, I'd say it's about time at some point.
But you know what? But when there be two issues with that. Number one, sovereign immunity, right? The governor sends people, you got the sovereign immunity issue. You can't prosecute the states because they have sovereign immunity, the 11th Amendment. And then if they have given immunity to these nursing homes, then you still have the 11th Amendment problem. So I don't see how you get around it unless you can make a 14th Amendment issue, right? And
exactly.
Unless you can make a 14th Amendment issue.
It created a circle where the state has immunized themselves for their bad acts and are already immune under the 11th Amendment, and then turn around and immunize the nursing homes for anything they did at the behest of the states. So nobody is on the hook for these people dying unnecessarily, and it's a problem. But
it's not just that nobody's on the hook. Everyone who contributed to the problem is off the hook, and it's the same thing with the idea of the vaccines. It's like everybody who could potentially be on the hook, even for wrongdoing, is off, and it's like I don't know how you instill confidence in the electorate by acting like that. It's obvious, but it's terrible.
So, but sometimes you just can't recover, though, unfortunately, and that's just it's just. Unfortunately, I think Cuomo made a huge mistake by sending people back to nursing homes. But as soon as you immunize them, then what can you do? What can you do? And the Justice Department, I just don't think they can have a case, because unless they can show that these people intentionally wanted to kill these people, then they really have no case. Unless they can in some way show that there's some equal protection issue, which I think I would go to, but I don't think you can even get there.
They may have some civil fines under the HHS rules.
Okay.
Yeah, things like that. That's where I think they're probably going to end up, to try to discipline people to not do it in the future. Have the state write they'll probably be writing checks. It'll be agreements and things of that nature. But yeah, I agree. There's not much else that can be done.
The one thing that blew my mind in looking into that Pennsylvania case was the secret agreement they entered into to allow the car show at the very same time. It's so in your face, and how stupid do they think people are that they're not going to find out, and that
pretty stupid. It was a secret agreement, but let me tell you all about it. That was a nice little trick. Yeah, it's nice to be the judge.
All right, people, let's do this. I think I hear a lot. Well, I had better go, and I've got it's 2.25 hours. This has flown by. I think people liked it. I think we should do this more often. We have to balance it out. I'm going to think of possibilities as to what we can do, to do this more often. But Robert, Kurt, Nate, thank you tremendously. Kid, thank you also.
And for everybody out there, you can follow the Viva Frei on Twitter. Subscribe to Uncivil Law and Nate the Lawyer's channels. They have good content up on a daily basis. And remember the two eternal truths: Sally Yates is corrupt, Epstein didn't kill himself, and when it comes to Amy Coney Barrett for SCOTUS, just like cocaine, just say no.
On that note, everybody, thank you very much. Gentlemen, stick around. We'll say our proper goodbyes. We'll do this again, everybody. Enjoy the rest of the week, and take care.